All rise. Hear ye. The Court of Appeals of the State of Michigan is now in session. The Honorable Matthew S. Ackerman. Presiding, the Honorable Philip P. Mariani. All persons having business herein draw near. Your petition they shall be heard. God save the United States, the state of Michigan, and this honorable court. Please be seated.
All right, good morning. This is panel 4 of the court's August 2025 case call session. Just on behalf of myself and Judge Ackerman and also Judge Kelly, who, to be clear, is on this panel, will be participating in the disposition of these cases. She unfortunately can't be with us here today due to illness, so we're wishing her a speedy recovery, but she is at home listening intently and is present on the panel for disposition. But on behalf of the three of us, welcome to the court. We are ready to begin our 10 a.m. session for the day. Thank you all for being here. Just a few opening remarks. Counsel, just remember, when you come up to argue, please put your appearance on the record before you begin. If your clients are in attendance as well today, please let us know that so that we can welcome them too. If you are dividing your time with any other endorsed attorneys who are here with you today, please inform us of that at the outset, and we can help you manage that. I also ask you to please keep your own time, though I'll do my best to help you. By way of a reminder, in cases where there are attorneys endorsed on both sides, it's a maximum of 30 minutes per side. If only one side is endorsed for argument, that's 15 minutes maximum. Please rest assured that we are very familiar with the relevant facts and law for each case. So please focus your time and efforts today on your most salient points or the points that you feel like perhaps weren't made as clearly as you would have liked them to be in your briefing. And of course, on any questions we may have for you. Importantly, because these proceedings are being recorded and will be posted publicly online, we ask that for cases that involve children or other vulnerable or protected people, please don't use those individuals' names, but instead refer to them by initials or other identifiers that don't divulge any personally identifying information. And lastly, counsel, I apologize in advance if I mispronounce your or your client's name. Please do correct me if I do that. It's important to get that right. Anything from you, Judge Ackerman?
Nothing else.
Okay, well then let's get started. We look forward to hearing your arguments. So that we will begin today with item number 14. And this comprises 3 cases that are consolidated. And let me read the 3 out and then we'll get started. So docket number 364803, People v. Bishop, 365083, People v. Charmel Teague, 365872, People v. Larry Edward Teague Jr. And I believe we have a collection of different endorsements and arguments and what have you from both sides. So counsel, perhaps you can let me know what the plan is to proceed. Since the cases are consolidated, the defendants collectively have 30 minutes to divide up as.
I was just going to ask you that, Your Honor. So thank you for clarifying. Jacqueline McCann on behalf of Romanye Bishop. And I think that Mr. Simon is not here with us, so I'll divide my time equally with Mr. Rupp.
Okay.
Your Honors, I am aware that you have 3 briefs from the defense side and a brief from the prosecutor's side, and they contain many of the same issues. I'm not going to go over each issue individually. I would like to say that for the issues raised in Mr. Bishop's brief, I think with the exception of perhaps the first issue, they can be categorized in sort of two buckets. The first being errors that went towards making the decedent seem perhaps in a better light than would have been done fairly under the rules of evidence, and then in perhaps making my client seem worse in a prejudicial manner not allowed by our rules of evidence in the Constitution. And so I would ask you to seriously consider the cumulative effect issue that we've raised at the end of the brief, because sometimes I think what happens is, say the issue about the lay witness's testimony about his opinion about premeditation. It might be that there might not be a case that's won on that in many years. And there was a curative instruction as to the error where they used my client's post-arrest, post-Miranda silence against him. And, perhaps individually, even though we've made arguments why we should carry the day individually on each of those, but if you put them all together in the cumulative effect argument, we would ask you to seriously take a look at that. But I do want to talk about the first issue a little more in depth, which is the denial of the request for the voluntary manslaughter instruction. Think that Yeager is illuminating in the sense that for a long time, I think courts really focused on whether there was anger. Was it a classic, like walking in on your spouse and in bed with someone? But Yeager taught us that it doesn't have to be that sort of classic anger. It can be any mix of emotions. And certainly there was a level of anger here in that my client's mother was assaulted, not too long before they went back to the store.
It does seem like for that piece, at least, it seems like maybe there's a heat of passion issue or an immediacy issue as to that piece of
as to the assault on the mother.
Yeah.
I would say if that was the only thing, then certainly it would be a less strong argument that he was entitled to the voluntary manslaughter instruction. But I do think it goes into the weight along with what happens inside the store when Mr. Bishop and his stepdad go in, and there's words about what had happened, and then my client comes around and perceives that the decedent is reaching into his pocket and grabbing a gun during these exchange of words and about to shoot his stepdad. Now we can say that the jury didn't find that to be defense of others classical, but it has to go into the analysis of that certainly will rile up your emotions. And so we do think he was entitled to an instruction on voluntary manslaughter. Yeager also teaches us that just because the jury didn't choose the second-degree manslaughter or second-degree murder that they were instructed on, that doesn't mean that this is a harmless error.
Do you have or I guess what's your best case for the facts here? Because I understand you're saying there's, emotional excitement can take many different forms. It can be anger, it can be fear, it can be just this heightened emotional state. But you still need it to be the product of adequate provocation. And, case law has drawn some lines about what fits that bill. And I guess, do you have a case that presents a circumstance that aligns with this one where, you have and let me know if I'm understanding the theory correctly, but you have one family member that sees another family member, involved in a conversation or an argument. They get nervous that family member may get hurt. And that, if that's the theory, and that constitutes adequate provocation for purposes of voluntary manslaughter. It doesn't, as a fact pattern, it doesn't seem that strange. So I'm curious if we have it in our case law that says, yes, this is something that can meet this legal requirement.
Not that I can point to you as I'm standing here, Your Honor. I apologize.
I guess it's the best law in your brief, I suppose, is my question.
I would rely on what's in our brief, but I would also point out in the scenario as you were sort of constructing it for your question that in Mr. Bishop's viewing of that situation, I do think we also have to know that as he knows that his mother was hurt beforehand, so that if anything increases his fear for his stepfather at that moment. And I want to call this almost like a near miss for the defense of others if the jury didn't return that verdict. But I think the near miss has to go into the understanding of the excitement level he was at, and that voluntary manslaughter should have been a choice given to the jury.
Wouldn't those defenses conflict?
They do not, Your Honor, and there is actually good case law on that. So, because they're both intention, they're both they're both defenses of intention. They're not like competing mens reas. They both have an intentional
Defense
mens
of
rea.
others and adequate provocation for heat of passion they both involve animated emotions, but those are different defenses. I mean, they really require different things. And
Well, one is a complete defense, of course, if you're defending others, and one is still a criminal act, right? The voluntary manslaughter just lessens the act. But the mens rea of intentionally pulling the trigger is the same in both, and that's why they're not like diametrically opposed. And counsel asked to be able to argue this, and they are, you can argue them in the alternative under our case law. It'd be a little different if I was coming to you and saying ineffective assistance of counsel for not asking for the instruction. He had a plan in his mind of how he wanted to run the case. He wasn't allowed to run that alternate route. So I wish you guys had the clock that they have in the Supreme Court one, but hopefully I've reserved some time for co-counsel here.
Yes, absolutely.
Okay.
Yes.
Thank you.
Thank you, Counsel.
Good morning, Your Honors. Jeffrey Rupp appearing on behalf of Charmel Teague. She is not present with us. Just touching mostly on a few points raised in the written response from the prosecution with regard to allowing the detective to argue or answer questions that he felt my client was being deceptive when interviewed. Prosecution argues that he didn't say he thinks that she's guilty, but I don't see how there is any other rational interpretation of his answers to the questions, that he is the lead investigator or one of the lead investigators testifying at her trial for the prosecution. The implication and intent of the question and answer is clearly to impart an opinion that she was lying and that she is guilty. The prosecution cites People v. Sergis, but I would suggest that it's distinguishable. In that case, the court's rationale in part relied on the fact that there was a similar singular comment from an investigator who was one of 11 witnesses against a single defendant. Here, we had dozens of witnesses, but if we look through the transcripts, the vast majority of it has little direct impact on Ms. Teague. The testimony we have against her is that she was violently assaulted by Mr. Munerlin, that she makes a few phone calls, the substance of which we don't know, and that she's not present in the store when the shots are fired. So I would suggest that this is more than just a quote unquote stray remark in a large pool of evidence against her. With regard to calling my client's daughter, Bria, a liar on cross-examination, again, the prosecution cites People v. Bahota, but that's a case about rehabilitation, not a hostile witness. There was no attempt here for them trying to rehabilitate their witness. They were trying to tear her down because her answers didn't fit with their theory. And while it's true a party may impeach their own witness, there are limits. At some point, a line is crossed, and impeachment goes from argument. It goes from impeachment to argument, and in this case, I would say it's straight out attack.
Is it your position that the discussion of her being dishonest or her lying was elicited just by the prosecution? It wasn't brought up at all during direct exam?
No, it was, I think you mean cross-examination by the.
Yes, I'm sorry. Well, I guess tell me how it came in. I mean, it seems like you're blaming the prosecutor for this, and I want to know sort of if that is the sole place that this testimony came,
No, there were examples of co-defendants, attorneys, impeaching her credibility. But again, I would argue, or I would say that those efforts by other defense counsel were properly made. Questions were asked, points were made. They didn't go so far as to start straight out attacking or calling her a convicted liar. I think the manner in which the prosecution did it is offensive.
So you see a material difference, I guess, between sort of how that questioning was done and how the prosecutor did their question.
Yes, I do.
Okay, understood.
Anything else?
Nothing further from me.
Nothing further than.
Okay. With regard to the comments on Mr. Bishop's post-arrest, post-Miranda silence, the prosecution in its brief cites People v. Vanover. Again, I think that's a distinguishable case. In there, as I read the facts, the defendant, Mr. Vanover, testified in his own defense, and there was a concern.
Was there a curative instruction on that issue?
I'm not certain.
Okay.
But where I think it's distinguishable whether there was a curative instruction given in Mr. Vanover's case or not is he's painting himself as being fully cooperative with the police and investigators. The quotation cited in the opinion is that I volunteered 100%. I gave whatever they wanted. In contrast, here we've got Mr. Bishop during direct examination by his attorney acknowledging that the only thing he said when he was arrested and interviewed was, quote unquote, it wasn't me. And he explains that he stopped there because he wanted an attorney. I would say that barely cracks a door. It certainly doesn't kick it wide open. He doesn't try to claim that he was 100% cooperative. He specifically admits to the limitation of his statement, specifically in the first moments after his arrest, nothing more. I think importantly in Vanover, it's worth noting that there the prosecutor made the point and took the appropriate step of asking to address the court outside of the jury's presence, stated their opinion that a door had been opened, that they wished to go into this line of questioning about continued post-arrest silence as a form of impeachment, and the trial court granted that request. That is not done here. We just have prosecutor plowing forward through repeated objections. They claim it's not a constitutional error if no answer is received, but then also try to brush away that the fact that Mr. Bishop does in fact answer the question that he's entitled to or wants to enjoy his trial. With regard to the jury view of the scene, as mentioned earlier, there's a great deal of overlap in the issues presented by all three appellants here. With regard to this issue, I'll rely on my brief and ask the panel to consider the pleading considered by fellow counsel. Prosecutions had a full opportunity to respond to them. With regard to manslaughter as a lesser included offense, again, I would ask the panel to consider similar arguments from counsel. I think People v. Yeager makes it clear that manslaughter and self-defense are not mutually exclusive. In her brief, Ms. McCann offers a rational view of that evidence that Mr. Bishop is in there. He's recently learned that his mom was violently assaulted. He hears his stepfather in a loud confrontation. By his testimony, he sees Mr. Munerlin armed with a firearm, and he acts spontaneously in defense of others. Beyond that, I would suggest that it would be appropriate in considering Ms. Teague's case to take one step further back, because she's convicted on an aider and abetter theory. Again, she's not in the store. She never goes back. Her husband and her son walk to the store. The theory is that she reports to them being assaulted and that this sets in motion a series of events. My take on it is that it's based on heavy speculation and conjecture because we don't know what is said during those phone calls. But she's just been slammed to the ground, violently punched in the public parking lot in broad daylight, lots of people around. Testimony is that she makes a phone call immediately afterwards, I believe to her son, either to her son or her husband. Is it really unreasonable, beyond reasonable doubt, to think that she's experiencing emotional excitement in that moment, making that phone call? Let's say she's calling him up and saying, hey, I just got knocked down and beat up. You guys need to do something about this. She's doing this moments after being violently assaulted. After that, the testimony is that her husband, Larry, wants to, quote unquote, whoop his ass, not kill. Her son is carrying a registered and licensed pistol, but there's no testimony that she's aware of this at the time. Prosecution argues that there's conflicting evidence. There's a video. I would suggest that that's evidence for the jury to weigh and decide where the scales fall. But this jury was denied a valid option to consider, and that it's a structural error requiring a new trial. With regards to the issues regarding joint trials and the anonymous jury, I'll rely on my pleading as well as ask the court to consider the other similar arguments presented by counsel. And finally, I would suggest that the impact of cumulative error in this case is clear. It's demonstrated by the jury's verdict. There's a dearth of evidence against Ms. Teague. She has no gun. She's not present. She doesn't take her son to the store. The case against her relies on a couple of phone calls, the substance of which we do not know, and speculation. But with the detective calling her a liar, with the prosecutor calling her daughter a liar, with the prosecutor commenting on post-Miranda silence of her son, with a prejudicial jury view, and without a properly instructed jury, she didn't stand a chance. But if we correct these errors, I argue that there is a strong probability that the result will be different and favorable to Ms. Teague. I don't have any further comments unless the panel has questions.
No questions for now. Thank you.
Thank you.
And collectively, you have a bit of time for rebuttal. Counsel.
Morning, Janet McLaren on behalf of the people. I think I've adequately addressed all of these issues in my brief, and of course, I've done 3 of them in this case, so I think I've pretty much covered everything. I just would like to quickly touch on the voluntary manslaughter instruction. I understand what Sister Counsel is saying. I respect her greatly, but if you look at my information that I provided the court on page 33 of the brief for Charmel Teague, I'm talking about the voluntary manslaughter Yeager case, which was brought up by Sister Counsel. And it's true that I did also cite that case, but I cite it because it states that for voluntary manslaughter, the provocation must be sufficient to cause the defendant to act out of passion rather than reason, but it also must be sufficient to cause a reasonable person to lose control, not just the actual defendant. All right. So the argument that yes, there would be some anger if your mother was assaulted. Yes, there would be some anger if you were assaulted. Those are all true. But not only would this not cause a reasonable person to go kill someone or assault them, right? But also that so much time had passed. There was a significant amount of time between the phone calls back and forth to the time that actually someone got into a car, all of them got into a car and drove to Family Dollar. And not only that, but once they're in Family Dollar, Mr. Bishop is walking around. There's sufficient time there. The video shows this and the testimony shows it for him to calm down so that he would not act in this manner. And the same also for Larry Teague. When he's in the car and he's saying, you know, I want to go fight this person, I want to go, you know, he's swearing and getting upset and things are starting to escalate according to all of the testimony in the case. There's still enough time, even once they get into Family Dollar, to calm down and realize that this is not a situation where they should be actually assaulting or killing someone. So I would just argue that the judge made the right call on this, that this is not a passion case, which is exactly what the court said. If I could just quote, this is not an emotional excitement case. It does not apply, and it would be inappropriate to read to the jury. So I think that the
Counsel,
court.
but it sounds to me like right now you're focusing on the altercation with Charmel. And then I guess I would like to focus in a bit more on the subsequent interaction with Mr. Teague.
Yes.
And why it seems like there's maybe 2 reasons why you wouldn't give the instruction here. One is that, you know, the fact pattern, even if you kind of take the defense's theory of it is true, that, you know, Mr. Bishop saw Mr. Teague and, you know, I got scared that Mr. Teague was going to get shot. So that heightened state caused him to act.
Mhm.
It seems like one reason why the instruction wouldn't be appropriate is because that fact pattern as a matter of law cannot be adequate provocation.
I would agree with that.
What can you point me to let me know you're right?
Okay, well, first of all, we have the video, right? And in the
Well, I
video.
guess in the law, I mean, setting aside, so I guess, I mean, there's a legal
Oh,
argument where if you just take that.
Again, I
you know.
cite on page, I'm sorry, misunderstood. On page 33, where I cite that it has to cause a reasonable person to lose control, that's
Why-
Yeager.
but why do we know that's not something that a reasonable person would lose control over? You know, seeing a family member that's about to be shot. Now, like I said, there's a second argument here where the evidence
Yes.
just doesn't rationally support that. But
I think then we have to look at the self-defense cases, and I don't have anything right off the top of my head that I can cite to you. But again, it has to be, you can't just be in fear. If you didn't see a weapon, right, which he says that he did, but there's no one else saw a weapon, and all of the people that testified, the video doesn't show a weapon. The police officer indicated during trial that she slowed it down, looked at the video, never saw a weapon out, as she puts it. What she, I think, inarticulately meant was that there's no gun from the victim scene. Yes, there's one next to his body, but there's nothing that hooks him up to that weapon. The serial number is obliterated. There were many, many people in the store. There was testimony that everybody around here carries a weapon. So
I guess let's change the facts.
Okay.
Let's just change the facts. and
Okay,
Say that.
that's scary.
Yeah, I know. This is when it gets fun. And then let's say it was clear that that the victim was armed. And that's clear. I know you're disputing that is clear in the record, and the rational view of the
Yes.
evidence does not support it.
Yeah.
I understand that.
Yes.
But let's move into a different world where there is a clear weapon, he's clearly armed. In that situation, you know, could a rational view of that evidence, just as a matter of law, potentially support a manslaughter? And if
No.
not, why?
No, you still have to have a reasonable fear that your life is in danger or someone else's. In other words, it has to be an imminent danger. And I don't have
So
the
the
law
weapon
in
has to
front
be,
of me,
like,
but I
drawn.
know that just from arguing jury instructions so many times in my career. It has to be an imminent danger, meaning immediate. And
Like the weapon has to be drawn, maybe, or something?
Yes.
Okay.
Yes. So I would say no, because you still have to have a reasonable person standard. And you know, many people, especially in today's world, there's people carrying guns all the time. If the standard was, if you see a gun, you can feel that, you know, you have the right to shoot someone, we'd be in a lot of trouble. And I do think that people report those to the police all the time because they're worried, hey, somebody's in 7-Eleven with a gun. I guess 7-Elevens don't exist anymore, but you know, somebody's in the party store with a gun. But you still, it's not reasonable to shoot that person. You can call the police and then they can go see if they have a CPL permit or something of that nature, but it would not be reasonable to shoot someone just because you see a weapon. You still have to have a fear of imminent death or that someone else is about to be killed imminently. And that just doesn't exist here.
Got it. So the fact that you see in your view, the fact that you see, you know, a family member involved in an argument with somebody who that you see to be armed, that doesn't get you to adequate provocation.
It does not.
Understood.
Okay. And unless there's questions, I think I'll rely on my brief because like I said, I've done 3 of them and some of them did overlap. I apologize
Yes.
for that, but I just made sure that I covered everything in each brief.
No, it was well presented. Thank you.
Thank you.
Any further questions for me? Okay, nothing from me.
Thank you.
Thank you, counsel.
Thank you, Your Honors. Just very briefly, in our statement of facts, and I think some of the other statement of facts, there is one witness who, from the store who says that's, you know, the decedent's gun, because he carried it regularly. But then I think we were mixing apples and oranges a little bit because I feel like Sister Counsel was talking to you about the defense of others and the standard for defense of others. And we're talking about the voluntary manslaughter instruction. You can watch the videotape. I'm sure you've probably already watched the videotape, but his hand is clearly in his pocket. My client's behind him and indicates he sees the butt of the gun. So again, the jury didn't find it rose to the level of defense of others, but seeing that during this argument in the store, knowing what happened before to his mother, that's going to rekindle all of those passions. And
But
seeing,
I guess what about Sister Counsel's point about, you know, you maybe aren't quite there yet for a reasonable person to say, well, I think maybe he has a gun in his pocket. I see his hand in there. I'm going to shoot him.
seeing
Is that
somebody.
adequate provocation as a matter of law? Can we say a reasonable person can react that way such that the law will diminish their culpability?
I think you need a totality of the circumstances analysis. If I walk into a convenience store and I see a stranger arguing with the owner of the store or the employee behind the glass or whatever, and I see they have a gun on their hip, open carry, we're open carry state. I could see they have a holstered weapon on them and they're engaged in an argument with somebody inside the store. That's not going to be enough. It's the combination of the history that I know this person assaulted my mother. The person that's standing in front of them arguing with them is my other family member. And then they reach and touch, they reach for that gun. That's a different world, a different set of circumstances. And so the totality has to be taken into account. Thank you, Your Honor.
You got a couple of minutes if you like it.
Just one real quick point on the argument presented by prosecution with regard to the self-defense instruction. It's an accurate take on the law that we apply a reasonable person standard, but that's only the first half of the instruction. Jury instruction also goes on to say that if you're considering this, you need to consider it from the defendant's perspective. And if they honestly held that belief, even if they later turn out to be wrong, they can act in lawful self-defense or defense of others. So I don't think it's not so simple as saying, hey, would a reasonable person have done this if they could see the video and if they could see this and they could see that? It's from, in this case, in particular, in Mr. Bishop's perspective, did he honestly believe that his stepfather was in danger?
Well, that's for the defense of others.
Correct.
Okay. In a separate space when we're talking about voluntary manslaughter, correct?
Correct. I just wanted to make
Understood.
that clarification.
Okay.
I have nothing further unless you have questions.
No further questions.
Okay, those cases will be submitted. Thank you, counsel.
Thank you.
We'll move on to item number 15, docket number 373185, People v. South. Counsel.
Good morning, Your Honors. Edward Zani, on behalf of Mr. Kyle, the appellant defendant in this case. I'd respectfully request to reserve approximately 5 minutes for rebuttal in our case. And taking the court's instruction, I'm going to try and narrow down the concept of this case. I think it's a very broad arguments we made. We made, I think, plentiful arguments, but it comes down to this being a statute that's a matter of first light. The first time I believe it's been prosecuted, and frankly, the first time I know it's been challenged in the criminal setting before the Court of Appeals. It's MCL 75411T, the anti-hazing statute. And our challenge really comes down to, I think it's two-pronged in the briefing. It's one, it's a matter of constitutionality of the statute, coupled with the issue with the motion to quash from the district court, and as it kind of flowed through to the circuit court and their opinions attached there too. And I think to get to, I want to emphasize this a little bit more and articulate that the appropriate standard, talking about a facial challenge. Now, we're challenging this on First Amendment grounds. I think that space involves association, speech, et cetera, et cetera. The proper rule, I think, for this case, the prosecutor cites that it's our burden to show that no circumstances in which this statute could be constitutional. I think that's wrong. I think there's an exception when dealing with First Amendment issues on a facial challenge. I think the appropriate rule is, as cited in United States v. Stevens, a U.S. Supreme Court case from 2010, articulated in our brief, that we don't need to establish under all circumstances the statute is unconstitutional. We have to show a substantial number of its applications.
It's an overbreadth argument.
It's an overbreadth argument, exactly. But I think that's the appropriate standard in conjunction with its plain and legitimate sweep. In understanding the plain and legitimate sweep, I think it's incumbent upon us, and this is where I think my brief fell short for the court, to look at the legislative intent and the purpose behind the statute. So I did that in preparation for today, and I looked at it, and the problem identified by the legislature in this case was articulated around sports, and that 79% of the individuals involved, sorry.
It specifically lists this as a form of hazing in the statute. This seems exactly like the type of conduct the statute is targeted at penalizing.
What is this in particular to your question? Just
Find the,
no, if it's based in the statute, or are you talking about a factual scenario?
in the statute, which is what I'm reading. Yeah.
Yep. But are you talking about in virtue of sports or in conjunction with the allegations in this case?
1 second. Hey, keep going, please.
Thank you. And I'll be more than happy to address and I'm not trying to step aside to your question. I'll be more than happy to address it at the appropriate time. But I think when you're looking at this, we have to, again, put it in conjunction with the concept and the purpose of the legislative intent, which addressed 79% of people in sports, I believe it was mainly collegiate sports, reported hazing activities. I see.
This statute specifically expressly includes activity involving a consumption of a liquid alcoholic beverage, liquor, drug, or other substance that adversely affects the physical health or safety of an individual as a form of hazing. And it specifically describes the purpose of pledging in the hazing definition. I mean, that this seems to target exactly this conduct.
I think that, okay. I would say that the statute's written that way. I would say the legislative intent behind it, as I was addressing, goes to something else, which created an exception for sports. But to your point, I think that's a question of the facts and circumstances in this case. And I do recognize the statute talks about specific conduct, but it is very much in the context of the constitutional challenge at which we present that it's overbroad. And it's not just that specific conduct.
What shouldn't, I mean, if you're going to make an overbreadth argument, then you do have to tell me sort of what is in there that shouldn't be.
One, I think the targeting of certain associations in virtue, in parallel to other associations being excluded.
Well, is this a First Amendment argument right now or equal protection?
Well, right now I'm talking First Amendment.
Okay.
Equal protection, I think, would be admittedly a harder standard for us to prove, given the low level of scrutiny that we have to look at that. However, I think they work in conjunction with, again, the legislative purpose. In this case, what's unconstitutional about the statute, on its face is not just, and I think as applied is a totally different analysis, and we reserve that, and I think we articulated in our brief. But here, the level and scope of the type of First Amendment conduct in which it touches and offends. I think that's.
I guess, so just the statute criminalizes conduct that intentionally or deliberately or recklessly, endangers somebody else. I mean, there's more criteria I'm summarizing, but I guess where does the First Amendment protect associative conduct that recklessly or worse endangers the associating members' health or safety? You point me to a case that says this is a First Amendment protected right to endanger the health and safety of the members of the association.
Well, I think that's exactly the issue we're presenting. I think we gave several levels of analysis to that kind of conclusion. And it's not going to be in the concept of a fraternity and a party where they consume alcohol. I think what you're going to see directly to your question is those scenarios that we presented where you have other student organizations engaging in political speech, engaging in their association, engaging in political speech.
But does the statute sweep that conduct within its scope? This all speaks to pledging and initiation.
No, I think it's broader than that. It's more than just
Criminal
pledging.
liability is contingent on the resulting harm, and the resulting harms are death or serious impairment of bodily function. It's
Bodily injury.
Bodily injury.
And I think it's
Sorry.
knowing intentional or reckless conduct where that's likely, right? Where that could happen. I think we have to look at it in the context of today's society to answer your question, to give you some fair
please.
ground to make that assessment. So look at it. I think I analyzed, a student organization that's Catholic based that talks about fasting and during Lent. I talked about
is the fasting causing death? I think
Could
that
it?
you could prosecute that plausibly if an organization in the name of religion is, creating a practice of hazing that causes death. I think that you actually could. In which examples do you have where the fasting during Lent is, causing death?
Well, there's the other part of the bodily injury. And I think to your point, I think I disagree with you. And I think when you use the word quote unquote hazing, it perverts the concept of the act. And I say that to make it criminally liable. Let's say you have this Catholic organization or a Muslim organization recognizing certain aspects of fasting during their religious practices, right? This is one aspect, but I think there's a more compelling argument. In that process, I think what we're going to see is, say we're a Catholic group, we're on campus, we're practicing, we're fasting, and somebody falls ill because they just needed to eat. And that person goes to the hospital dehydrated. That could, because by virtue of their affiliation with that Catholic student organization, because of the mandate of the organization to participate in your Lenten promises, and that person falls ill, that's exactly a scenario that would be prosecutable under these set of circumstances under this statute. But I think more so compelling, and one, I think we need to encompass kind of the change in society that I'll bring up as far as a distinctive aspect of the prosecutor's cases they presented. There's a change in society. Let's put this in the context of politics, right? That's, there's a lot going on in politics, and just go back 3 terms. Go back from 16 forward. Let's talk about what's happening on college campuses. Let's talk about the activities of student organizations. Let's talk about historically passive resistance is prosecutable, depending on who the prosecutor is and the culture or the climate you're in. That created significant change in society. Here, it criminalizes any act that could be deemed a criminal as a part of hazing and coupled with the association. And I think it's not just a fraternity. It's broader than that. It's any organization, any association, any group that goes to middle school. It starts at middle school under this statute, which again comes as to, I think, the appropriate notice requirement. This is the bigger challenge in that when you look at these opportunities, how many times have we seen violent acts occur at student protests? In society, in the news, not in this case fact-driven, but in our society, it's consistent. I would have fear for my kids to go to a campus and protest a certain political position as part of a group because I think there's a likelihood they could be injured given the way our society has shaped these days around political issues. Black Lives Matter, Republican, Democrat, whatever issue you think you could put out there, gun rights, whatever issue you think you could put out there, it creates a dynamic specifically on campuses, which I'm just articulating. But again, this goes to middle school. It's broader than that. So I think those are the scenarios where it really does impinge on the First Amendment grounds in several aspects that correlate to this unconstitutional on its face.
Right, and just pulling this back, though, I understand your, it still is it's an overbreadth challenge, but it still is a facial challenge, right?
Correct.
You can identify as applied instances where, maybe this presents an interesting question about the constitutional application, but to translate that even into an overbreadth facial challenge, it takes more than saying, hey, I can think of some instances where maybe this is questionable. You really need to demonstrate a substantial mismatch between the First Amendment protections and the statute, which I think, and that is ultimately, I think, the hill that you're at the bottom of with that sort of challenge.
But I think I'm going up, and I know it's an uphill challenge, and I recognize the difficulty in the facial challenge, and obviously we've, as applied, addressed this issue in our brief and rely on that. But I would say it's not a challenge that can't be overcome because I don't think it's just, I think it's unfair, respectfully, for this court to expect me to articulate specific instances in society that have already occurred that could support this finding. I have to give you scenarios because the standard under Stevens is provide the court applications of this statute that could be unconstitutional in conjunction with the plainly legitimate sweep of the intended statute. Well, it's affecting all these other organizations, religious beliefs, and other things when it's directly driven under the auspice of curtailing, quote unquote, hazing in sports. That's the purpose of the legislation when you look at the legislative history. So I think that's the balancing test, and I think I win. So I don't think it's an uphill battle. Respectfully, I think the constitutional rights of individuals win, not me individually, because I think this is broader than that and it affects many more people. And I think the analysis that I've given goes directly to that issue. And I think when you transfer over to the vagueness aspect, be it as applied or on its face, the Rogers standard, which sets forth the 3 parameters. And I think the one that I really want to articulate in, because I do believe, and I hope I properly address this in the briefing, that, let's talk about the concept. Under one of those standards, it's the statute fails to provide fair notice to prohibited conduct. If nothing else from this case, where's the line? Where's the line that you crossed? That's the difficulty in this case, especially when you look at it in conjunction with the fact that it goes to a middle school level students upwards, right? It's not just college athletes. I think one of the distinctions from a lot of the cases that the prosecutor had referenced was in the context of colleges and students and their expectations. Well, we have a duty when writing a law to convey notice to individuals. Well, it's not just analyzing the concept of a college student who's involved in an organization or an association or a group, right? It goes back to those younger kids. So I think you have to change the parameter as to where's our pinpoint as to who has to understand what. in this case, it's been challenged since the district court to the circuit court. What you saw is the district court issued an opinion on the interpretation of the statute. The circuit court, in some part in their order, disagreed with it. You had multiple attorneys disagreeing with the
It's an
context
issue
of
of first
definition.
impression, so, getting there, but what part of the statute specifically is ambiguous or doesn't give clear notice? Because, an intentional, knowing, or reckless act is something we have in many criminal statutes.
I think it goes to notice by virtue of the direct involvement in some of those terms, participation in the act. At what point, the way the statute's written criminalizes, and I'll put it in the context that the court may want to hear it. I'm at a fraternity on campus, and I'm a friend of a member at the fraternity. I go to that party, and I know that party's for the pledges. I'm associating with that group, okay?
Does
I'm
that person
participating.
Is that participation an intentional, knowing, or reckless act?
I'm
That's the
intentionally showing
question.
up to the party where it's a party associated around or situated around a certain group of pledges. They could be prosecuted under this. That's how broad I read the statute. And I think that's how broad the district court and the circuit court reads the statute, because it's participation in. You don't have to be directly affiliated. You could participate, be at a party. If we look at it from the facts of this case, the way it's presented by the prosecution, the mere attendance at the party in and of itself is criminal. Well, at what point does a party attendee know the line is being crossed? I'm observing people drinking. I'm observing people being focused on. I'm observing X, Y, and Z that they could use to articulate their basis. But I'm not a fraternity member, but I'm participating in their party. At what
Is
point?
participation a reckless act directed at an individual that endangers the physical health or safety? I think that is, that could be, there could be a line where that becomes difficult, and I don't think that we need to decide today whether just an attendee, I mean, those are not the facts of this case, but I also don't think that's categorically not giving notice. I mean, we have difficult decisions in a lot of areas of criminal law of whether something's a reckless act or not.
Respectfully, I would disagree with Your Honor. I think this case is very much more in line with just being at the party, because that's going to transition into this argument as it parlays into the concept of what are the facts of this case, and what is this issue with the motion to quash, and what are the elements of the offense. The district court said one of the elements is actual force, but force, though not used in the statute.
I don't read force in it. I mean, consent is in the statute explicitly not a defense. So if you can consent, how can force be required?
Which would create the ambiguity in the statute, right? And then the circuit court.
An ambiguity, just consent isn't a defense. We have that in other statutes.
But I agree, but then to some degree that weighs heavily on the concept of notice, right? If in this context of a party, if I have people actively participating in consuming alcohol without any force, in this case, there was clear, no force was used, right? That was a lot of the questions that I had preemptively asked the witnesses. But that's exactly the point. Creating that consent's not a defense. If we're talking strict liability under 16 and CSC cases, okay, that's different. They can't consent. Here you have adults that can consent and participate, and then I'm structured in the position to have to judge where I'm crossing a line when I have an active participant in a rather, I would say, legal position to engage in the conduct. I think what we're doing is there's a lot of gray area in here that's tantamount to overall ambiguity. And I think that's our challenge. Tying back to your question, these facts, I think we really have to understand what the facts are respectfully. We don't have, the district court had opined on several of the facts. One of the major facts that they opined on was, there's no evidence to support that my client brought alcohol to the party, right?
There's evidence that the pledges waited in the basement until his arrival, and there were 20 shots for 4 pledges. There was a dangerous drinking ritual called scrolling. That he was pledge master and led this, was in charge of this process.
I would disagree with the court again, respectfully. I think, yes, there's evidence he was the pledge master, but in that very same record, you're going to see that his role as a pledge master ended. That at the time in which this event occurred, his role as the pledge master had ended. Again, coupled with the fact that he did not provide alcohol. And to the court's point about these 20 shots, I don't think the record's clear as they waited for these 20 shots to occur. What really the court deduced specifically as it relates to Ethan Cow, and I think one of the bigger challenges when we start talking about the constitutionality, the conduct of the organization creates criminal liability to any one of its members or attendees. And I think that's I think that's a really big concern for overbreadth, because the way it's written, it could inculpate you for just being there, participating in the activities. And so to my client's position, really the court deduced that what? He was at the party, showed up late, left early, right? That he, though they had this role, that role had ended. What the court was really relying heavily on is the fact that he was cheering. A First Amendment protects speech. He was cheering. Then they coupled that with the aiding and abetting theory, that he was cheering on the complaining witnesses, the pledges purportedly in this case, and it's captured on video evidence. Well, the aiding and abetting theory, as we look, has to be with the perpetrator of the crime, not with the complaining witness of the crime. There's a distinction there. And then by showing up to a party and cheering, does that not invade the province of the First Amendment? I think it does.
One of the victims described him as, quote, the authoritative figure of the entire process.
For pledging, not for the party. This was a party designed to celebrate the crossing over. They were now pledges. They were now what's called neos. And yes, they had a certain purpose, but they also say my client had very hands-off approach to planning. My client wasn't part of the E-board, was part of that. And part of this record talks about who the E-board was. Noticeably absent from the E-board was my client's name. So I think there's a huge distinction from those facts and level of facts, especially when it gets to probable cause, as to really what level and what role he had in this process. And I think it's overstepping when you look at the district court's conclusions and thereby the circuit court's conclusions. And I think what was tantamount in that process was expounding on this concept and deficient definitions in the statute, which essentially was legislating from the bench. Now, I know I lost track of time, all due respect, Judge. So I think I have reserve some time for rebuttal. If you have any more questions, I would like to at least address that in rebuttal, some of the issues with the prosecutor.
You'll have a couple minutes.
All right, thank you.
May it please the court, Jerry Scroton, Ingham County Assistant Prosecutor for Plaintiff Appellee. Now, at base, defendant's argument is a statute forbidding recklessly harming someone is unconstitutional. And that's just wrong. Which is why no case in the country has ever declared this kind of a statute either facially overbroad or vague. And it certainly isn't overbroad or vague as applied here. In the first place, drinking alcohol to excess is not free speech. No. And the association freedom does not apply to an activity that includes reckless behavior like this. Now, yes, there has to be, overbreath does allow, even if it's not quite this situation, but it has to prohibit a substantial amount of free speech. It's a realistic danger that the speech would be significantly compromised and strong medicine, and to be used sparingly and only as a last result, of course, in my brief. Those are straight out of my brief. Now, defendant comes up with a number of possible activities, but the statute still requires recklessness. In his situation, is it reckless what they're doing? Person going through a fast, many people have gone through a fast without being injured whatsoever. Is that reckless behavior then? Particularly if they are monitoring the people under those situations. Now, defendant made a rather interesting statement here that a statute's written that way, but we are to look at legislative intent. No, that's not how we do it. We start with, how's the statute written? If that's how it's written, and we can, if it's clear enough, that's the end of it. Fair notice? Well, reckless act has been legally defined already. And besides, Everybody knows that you're not supposed to do something that injures somebody else. Everyone kind of knows that. I'm asking that this court not be the first court to declare such a statute unconstitutional. Otherwise, I rely on my brief and I ask the court to affirm. And if you have any questions.
I think I understand the constitutional arguments pretty well. But yeah, I guess I'm more interested in this case right now, and the facts. And, brother counsel has raised a bunch of, points from the record that indicate, Tim, that there was not sufficient probable cause that his client, was involved enough in what was going on to incur criminal liability. And I guess, tell me, I understand we have your briefing on both sides is well done, but highlight for me the most salient points that show that, yes, the bind over standard here was met.
Okay, we start, of course, with the standard. It's probable cause for a bind over, and that's not much. That doesn't require even a preponderance. Only probable cause and abuse of discretion for the district court. Okay, de novo for the circuit court, but abuse of discretion for the circuit court. What we have here, number one, he's not even challenging anymore that he was a student at the time. Okay, number two, we have something specifically, one of his text messages says, I am bringing ALC, ALC. I wonder what that means. He brought alcohol there, and he was the pledge master. He was, to a very large extent, in charge.
Now, the
of
counsel
what,
says that role had ended. Is that found in the record? Is it disputed?
no,
in
it
the
is
record?
not. No, he's just interpreting the record that way. This guy is one of the top people there. There isn't anything, all he's doing is saying, well, the record kind of shows that he stopped really saying anything at this point. But, and let's also not forget, afterwards, he wrote some text, basically kind of accepting responsibility for it. All we need is probable cause. If there isn't probable cause here, well, then police have a very difficult time arresting people. It's probable cause. Yes, there is a difference in that the police don't need legally admissible evidence, and for a prelim we do, but there is probable cause that he was still in charge. Okay, let's say that the governor shows up at something, at an event put on by the state, and the governor doesn't say a word. Governor is kind of still in charge. I asked the court to affirm. Those are the salient points. And of course, there was a death, and the other three went to the hospital.
No questions.
Okay, thank you.
Thank you, counsel.
I'll make it brief for your honors. To your question, page 107, line 23, Mr. Cowell's role as pledge master was complete. Agreed? Yes. It's lines 23, 24. No clearer is the fact on the record. And the problem I'm seeing with the prosecutor's briefing is there's often a jump into conclusions of facts that's not on the record. For instance, I scoured the record for the concept of whether or not, and in their brief, they said there's no freedom of, no First Amendment right to serve alcohol to minors. There's nothing on the record to support that they were minors. I spent hours. If I missed it, then maybe I should just retire, right? Because that's the amount of time I looked at trying to decipher if I missed that. I ran this prelim for days, prepared for weeks. So I think in tying it back, that aspect, the issue with class, him being a member at Michigan State, the statute specifically requires that he is enrolled at Michigan State at the time in which the event happened. I did not.
He had a text message that said, I'm in class, dude.
It's like saying I'm in court, dude, to my wife, my kids, my clients, my staff. What
Probable
court?
cause stage, there's probable cause that he's a student.
But that's
I'm
the
in class,
question.
dude.
Sorry, I don't mean to be rude or cut you off. The district court concluded that the people's position was that there was unequivocal testimony that he was a member at Michigan State. That was a question that was asked under objection, 2.5 pages of voir dire, and it concluded with, the guy didn't know. So I don't think it's safe to say, and the essence of the text messages.
Trial court also found that that witness had impaired credibility due to his friendship with your client. So
that still was leaving the record lacking. The circuit court, you know what the circuit court said I had the obligation to do? They said I had the obligation to clarify what being in class meant. Why would that be my burden at a preliminary exam to establish anything? They had to, as far as probable cause. Every one of the courts looking at that said the evidence relating to his class enrollment was thin at best. And they were finding a way to connect the dots for the prosecution, which I don't think is fair. I think when you look at this, probable cause still has a meaning. I'm in class, but what class? The statute specifically requires you to be a member in enrollment at Michigan State University for this case. And then I'll tie it up on the concept of these out-of-state cases as persuasive authority. 3 of the cases did not use the appropriate standard when addressing a First Amendment issue. All of them were assessed from, I believe, an aspect of the collegiate level, the college level students, and not the way this statute expounds on many more people. And I think one thing that goes directly to the heart of my biggest concern with the change in society is the statement from the Illinois Supreme Court. And I'm going to read it if I can see it. It is difficult to imagine that teaching Twain, satirizing political figures, or criticizing courts' opinions could result in recklessly knowing or intentionally causing injury to a person. If nothing else, from what we've witnessed over the past 10 years, give or take, that is exactly the issue. And that was a 1992 written published opinion in the Supreme Court for Illinois. They would just be haunted by the fact that they said that in conjunction with what we see in society today. And I think that's where it requires a bigger picture to understand this affects more than just fraternities, and it takes away certain associations by virtue of benefiting others. Thank you.
Thank you, counsel. Okay, that case will be submitted. Item number 16, case number 369576, People v. Cook. And I believe we have counsel for appellant appearing remotely.
There we go. Good morning, Your Honors. Laurel Kelly Young on behalf of Sharnay Cook. This is a difficult case. I raised some sentencing issues. I guess the issue that I think is most salient is going beyond the guidelines. I think in this case, what is required is rehabilitation, and I think that can be done within the guidelines. And I don't believe an extra 9 years is going to make the rehabilitation any better. So other than that, I rest on my brief, and I am welcome to take questions, or happy to take questions.
I think I understand your position from the briefing, counsel.
Thank you.
Morning, Your Honors. May it please the court. My name is Christopher Candela, appearing on behalf of the Eaton County Prosecutor's Office. Does the court have any questions for me? Otherwise, I'm going to rely on my brief.
I think likewise, the briefing was adequate to convey the positions on both sides, I believe. Yeah.
Thank you.
Okay. Yeah, thank you, counsel. All right, so that matter will be submitted. We'll move on to item number 17, People v. Hobart. That's number 370089. And Ms. Young, you're up again.
Yes, Laurel Kelly Young on behalf of Jesse Hobart. And in this brief, I have raised sentencing issues as well. And I'm happy to take questions. Otherwise, I have briefed the sentencing issues, the guideline issues.
Any questions?
I think the briefing conveyed the item as well.
Okay.
Thank you.
Good morning, Your Honors. William Warden, Assistant Prosecuting Attorney on behalf of Livingston County. We're asking the court to affirm the guidelines issues involve OV 13 and OV 17. And then there's a sentencing proportionality issue, which I've addressed in my brief. And I don't have anything new on those issues, but I'd be more than happy to take questions from the panel if you have any.
I don't have any questions.
Me as well.
Thank you.
Okay. Thank you. Okay, great. Thank you, counsel.
Thank you.
All right, that case will be submitted as well. We'll call item number 18. That's case number 366-255. TPM, the Board of Hospital Managers for the City of Flint.
May it please the court, Tali Wendrow on behalf of the plaintiff appellant. The central narrow issue on this appeal is whether the evidence that was presented at the Daubert hearing was sufficient to get past the court's gatekeeping function. And to that end, we submit that the short answer is yes. Defendant appellee argues that the trial court did analyze the reliability of the proffered testimony. However, the court's opinion is replete with doubt based on differing interpretations of the record. To that end, his opinion is based on weight and not admissibility, and we're requesting that the court reverse. Nurse Ridgely formed her opinion that, number one, the standard of care was breached by failing to advocate or go up the chain of command with respect to the March 17th hospital discharge. And number two, that the standard of care was breached by failing to reassess TPM while she was in the ER waiting room, having triaged her at a level 2 upon her arrival. These opinions were formed based on her review of the various depositions and the medical records, and her testimony was therefore sufficient to establish the requisite reliability required by MRE 702 and 703.
It seems like the court's concern, at least with respect to the kind of, I guess, the advocacy opinion, was the connection of going from advocacy to sort of the discharge step. Am I right? Is that where the
Yeah.
courts seem to feel like the thread was lost? And I guess, tell me why that was wrong.
So yes, the court did state that her opinion was too general and unconnected is the word he used. Yet Nurse Ridgely did connect it. She noted that the nurses failed to advise the PA, the physician's assistant, about pain and vomiting. And there was also a notation on the March 17th record that the patient was tearful because she was still experiencing nausea, and that it was based on the record in its totality. When I say record, I mean the medical records as well as the testimony from the patient and her mother. And she was connected. So
I guess is the argument then that the nurses didn't do enough to inform the PA of the status, or that they did inform the PA of the status, but then when the PA made the decision, the nurses needed to then come back and say, I really think this is not the right call.
That they didn't inform her, that it's not contained in the record, that things weren't documented that were in terms of the vomiting and the pain, and that she therefore should have either, gone to the PA and noted these things, and then if the PA didn't respond, then go up the chain of command. That was her criticism as far as the March 17th date. With regard to the March 19th date, I'm going to focus now on the judge's ruling in that respect. He again held that the facts and data were inaccurate and insufficient was the language. However, again, Nurse Ridgely testified to the record as a whole. She explained that the failure to take the vitals during the ER wait, the judge says that argument went nowhere. However, Nurse Ridgely testified that simply checking yes, if you recall that reference to the medical record, and it notes, I think at 5:28 p.m., about an hour after she was there, vitals, and it just says yes. That simply checking yes did not mean that the vitals were in fact completed. And if you look at that entry, it doesn't reflect what those vitals were. So again, what weight to give her testimony of her otherwise reliable opinion based on her qualifications and the record that she reviewed as a whole and the depositions that she reviewed and the letter from Dr. Wilson, that should have all been left to the jury. Addressed that already. While the defendant argues that the trial court did not make credibility finding, it is our position that the court indeed did usurp the role of the jury. Upon their cross-examination of Nurse Ridgely during the Daubert hearing, defendants focused on their questions that specifically related to TPM's credibility and that of her mother by suggesting that there was no evidence of the syncopal, I never pronounce that word right, the syncopal event. They seemingly accepted that the video, the judge, I think, seemingly accepted that the video, which Dr. Wilson testified that Dr. Jaggi told him that he did watch, doesn't exist at all. Regardless, the testimony that Nurse Ridgely presented as a whole, and based on her experience, was sufficient to meet the standards under MRE 702 and 703. The trial court abused its discretion in finding that the nurse's expert's testimony was inadmissible, and therefore the grant of summary disposition should be reversed, and Nurse Ridgely should be reinstated as an expert. And I'll reserve any additional time if you have any questions.
Any questions for now? None for me for now.
Okay.
Thank you, Counsel. Yep, you have time for rebuttal.
Morning. May it please the court, Jeffrey Garish on behalf of Board of Hospital Managers for the City of Flint, DBA Hurley Medical Center, which is a mouthful. One thing I didn't talk much about in my brief, but I thought I'd mention today, this issue got unusually thorough treatment by the trial court by not one judge, but two. Judge Farrah held a Daubert hearing, then took supplemental briefing, and then issued a pretty thorough written opinion. Then there was a motion for reconsideration, and Judge Christensen reviewed that and said not only did Judge Farrah act well within its discretion, but he thoroughly applied the law correctly. I think the judge got it exactly right, both did, and they certainly acted well within their discretion. On the March 17th issue, not only is the standard is just too general. I mean, according to plaintiff, it was basically any action inconsistent with the obligation to provide optimal patient care. Well, that literally is it's a completely meaningless amorphous standard. And Judge Farrah correctly recognized that you can't extract a cogent standard of care based on that very generic statement, which makes it unreliable, inherently unreliable. And then what he also pointed out is, and I think this is in a footnote, Nurse Ridgely couldn't even say whether the PA, the physician assistant, Sarah Guerin, would have acted differently or that she was missing any information. So there's a very significant causation problem that was really kind of parenthetical, but I think it's significant as well.
I mean, is that a proof? Is that just a general proofs issue, or does that go to? I mean, is this just a standard of care expert? Does Nurse Ridgely's opinion about standard of care become unreliable simply because it doesn't also comprise, causation?
I think so. I mean, there's got to be, there's definitely two potential flaws in it, but one is a lack of causation, but it's causation in terms of whether the action they say the nurses should have taken would have made any difference. And I think that goes towards reliability a little bit, at least. And Judge Farrah recognized that she had absolutely nothing going for her in terms of reliability other than her qualifications. She was qualified, but then she just had this generic standard that didn't have any cogent standard of care applicable to a discharge. And that was.
We should have some I mean, I understand your point about the standard that she ultimately offered being, I guess, too general to be reliable or useful or whatever. But it seems like there was at least some literature support for that general standard, some, sources that she could point to in addition to her experience to say, hey, this is the standard. Now you can say that standard is, not useful enough to be admissible. But I guess in terms of its factual support, where's the big deficiency?
It's just too amorphous. I mean, this is the literature and I'll quote from the actual literature. The nurse promotes, advocates for, and protects the rights, health, and safety of the patient. Again, That is a completely standardless standard. No matter what was done, no matter what the circumstances, that standard would be violated. And that's why it's just way too general to qualify as a cogent standard of care applicable to these facts. What they're saying is the Nurse Swift should have essentially tried to cajole the doctor or the PA into not discharging her when they don't even know whether she was lacking in information. Well, how can you, there's got to be an applicable standard of care for what a nurse has to do when there's a discharge order that is by the physician's assistant or the doctor. That's not even within the nurse's control. What is the nurse supposed to do in that situation? And to just say, provide optimal care is just, it's too generic. It's too generic. And I think the judge acted well within its discretion in agreeing with that, and certainly did not act outside it's a principal outcome. It's perfectly principled because it's just too generic. And then on the March 19th, she just didn't understand the record. I mean, she acknowledged in her deposition that there had been a reassessment done within an hour after she was admitted, which she didn't know that. And then when she found that out, she said, well, there was just the one assessment. But her opinion was formed based on the assumption that nothing was done for more than an hour. And then the other problem she has is she relies on Dr. Wilson's testimony, but that was based on nothing other than what the mother said to him. He thought Dr. Yagi had watched the video, but Dr. Yagi confirmed in his deposition that he didn't watch the video. So there's no substantive, objective evidence to support the argument that there was some negligence on the 19th in terms of letting her sit around for too long without treating her.
It sounds like perhaps there's a dispute in the record about the video being watched.
No, there's no dispute.
And
I
so
mean,
why is there no-
there's a misunderstanding. Dr. Wilson testified that Dr. Yagi told him he had watched the video and that it showed a less than stellar treatment. And then Dr. Yagi said, no, I did not watch the video. And he said, well, you were told, Dr. Wilson testified that you did watch the video. He said, yes, he did testify to that, but I did not watch the video.
But does Dr. Wilson then said, oh, I misunderstood? Or is it, because that sounds like a dispute. It sounds like you have Dr. Yagi saying, no, I didn't do that. And then you have somebody else saying, well, actually, you told me you did. And
Well,
then that's something that a fact finder needs to sort out.
No, because there's no evidence that anybody watched the video. Dr. Wilson thought Dr. Yagi did, but he didn't. And that's undisputed testimony by Yagi, his deposition. I did not watch the video. So it's a misunderstanding in him because Wilson based his opinion on talking with the mother and on the supposed video, what the video supposedly depicted to Dr. Yagi when he watched the video, but he didn't watch the video. So there's no evidence that there even was a video that anyone could have watched. So you can't say that there's a question of fact on this when there's no evidence that anybody watched the video. The evidence is undisputed that there was a misunderstanding on the part of Dr. Wilson in thinking that Yagi had.
As Dr. Wilson indicated that has anybody gone back to Dr. Wilson and said, here's what Dr. Yagi said?
I don't know. Not that I know of. It's appendix page 663 is Wilson's testimony on this. And appendix page 540 is Yagi's testimony on this. And so again, maybe the bigger problem though, is that there was a reassessment done within an hour after arrival, which Nurse Ridgely was not aware of until it was brought to her attention in the deposition.
And was her response to that then, if I remember right, was, well, a box was checked. You don't really know what that means. Is that accurate?
Yeah, I think that's right. So, well, there was one assessment, she said, but that was within an hour after she had arrived. And she doesn't have any further opinion on that other than she just, okay, there was one, that's all that was done. But again, I mean, her opinion was formed based on the assumption that nothing was done. So, thank you.
Right, understood. All right. Okay. Counsel?
I think that's slightly misstating her testimony on that assessment. What she said was, it doesn't tell me anything. Simply saying yes might mean, yes, I'm going to do an assessment. If you look at that record, it doesn't say her blood pressure was this, her temperature was, X or Y. So
if I'm remembering right, it was, correct me if I'm wrong, though, it was, like a sheet with two boxes, one is yes and one is no, is that right?
And she
You
checked yes.
Okay.
Right. And then on the question of Dr. Yegi's testimony, with all due respect, it's a credibility question. I mean, Dr. Yegi might have been concerned about his own, he would have been the guy on the hook. I don't know. I'm not, my point being that
Right.
it's a question of fact. Clearly, did he watch the video? He said, he told me he did. He said, I didn't. That's not, I think what the judge did was just assume or just kind of accept that, well, maybe there wasn't even a video. He even, I can't remember his exact language, but he says it's not even clear that there was a video at all. So it again, it's disparaging the credibility of the plaintiff and her mother, and their testimony was also part of the record that Nurse Ridgely considered which, by the way, was corroborated again by her medical condition the next day. So
Now, I guess what's the point of the first, I guess, prong of the opinion with the advocacy of this standard of care just being, too general to be reliable, just as a matter of law? I mean, what can you point me to that? Because you can see the logic of that argument. Obviously, everybody's involved in healthcare has, an obligation and a standard of care to do their best by their patients. So, but it seems like I can see why that's not enough. So tell me, I guess, why that's not the right way to think about this.
It also ignores Nurse Ridgely's testimony that nurses effectuate the discharge. So yes, it's the order comes from the physician, or in this case, the physician's assistant, but they're the ones that effectuate the discharge. And if they had information, and again, there was, the record evidence that the nurses did know that she was still not feeling well, that she was still complaining of pain and vomiting, that they then have the obligation to raise that concern.
Because the nurses, so is your theory that the nurses had knowledge, there's evidence in the record that the nurses had knowledge that this patient really wasn't suitable for discharge.
Correct.
And their failure to bring that to the PA's attention post-discharge order was a breach of a standard of care.
Correct.
And do you feel like Nurse Ridgely's opinion as articulated is adequately precise to that point? Or is it just gleaned from a general idea? Well, of course, you're supposed to try to help your patients.
I mean, when you look at her testimony as a whole, it's supported by her testimony as I read it. Thank you.
Okay, thank you, counsel. All right, that case will be submitted. And we will move on to item number 19, case number 370336, Berlin v. Torres. And my notes reflect that we have a counsel for appellant not endorsed for argument, but counsel for appellee endorsed.
That's correct, Your Honor. Dennis Burr on behalf of appellant, and I did want to indicate to the court, my client, Ms. Berlin, is sitting in the gallery behind me.
Welcome.
Thank you.
Thank you.
Good morning, Your Honor. Victor J. Torres, appearing on behalf of the...
Please approach. So we may want to make sure you pick it up on the record.
Yes, Your Honor. Sorry. Good morning again, Your Honors. Victor J. Torres, P43240, appearing on behalf of defendants appellees.
Do you have any argument you'd like to present?
Yes, Your Honor. We will, as the court may expect, rely primarily on the filings and submissions to the court, as well as on the record in the lower court, which is the Livingston County Circuit Court, Your Honor, in granting a summary disposition to defendants under MCR 2.116, C7, and C10. Your Honor, for purposes of today's argument, I would like to focus on the primary argument that's being asserted on behalf of the plaintiff appellant. And I'll start by noting that at the time of her deposition in May of 2023, Ms. Berlin was a 17-plus year real estate broker. She had investments in 3 duplexes in addition to the home that she was attempting to purchase by land contract from Cal Torres and Laura Rooney, the sellers and owners of the property. So that's the backdrop on this. Ms. Berlin pulled off her computer, prepared the lease under which she started residing at the Greenview property in Fenton in 2012, then later acknowledged at deposition. And I should note that all of these statements that are making are affirmed through her sworn deposition testimony, Your Honor. So she also prepared the land contract at issue here. Cal and Laura, the sellers, did not engage counsel at that time. It was a document provided by Ms. Berlin.
And counsel, just, this is a case that's it's a little factually intensive, and rest assured that we are very familiar with those facts.
Very good, Your Honor. Let me get to the main point then. The problem with what the plaintiff appellant is arguing is the following statement from page 9 on the brief and appeal. The statement made on behalf of plaintiff appellant is that exhibits were submitted in response to summary disposition that support Ms. Berlin's position that the time frame for the balloon payment was extended. A question of fact on the issues exists. Well, that's the problem, Your Honor. There never was any evidence of record that there was any question of fact or that there was any extension of the balloon payment deadline, which occurred in June of 2019, Your Honor. That's why the trial court granted summary disposition. That's why the decision should be affirmed here. And I'll make one other point that's unique to this case. There was a verified complaint that was filed in this action, Your Honor. Understood. Now, what that often means is that the plaintiff's attorney that's accepting the representation is acknowledging the fact that there's certain facts that that attorney is not willing to sign on to under the former court rule of MCR 2.114, which is now 1.109. So therefore, because in a specific performance action, there's no verification that's required. In this case, it was required. Now, I'm sad to report to the court that the initial attorney on this case has since passed, but he was replaced by current counsel, so was represented, and again, relied on the verified complaint that had been filed previously. And so therefore, relied on that. And what's troubling about this case is in attempting to avoid summary disposition, an affidavit was signed by the same plaintiff here, the 17-plus year real estate broker. And the affidavit had just bald eyes in it. One of them was, to avoid summary disposition, we're going to go back to the first land contract that was signed by Cal alone, dated April of 2015. Well, by plaintiff's own deposition testimony, that land contract was never signed by Ms. Berlin. She knew, because they were married, Cal and Laura at the time, that she needed a signature on it. So therefore, the land contract that was really at issue, that was signed in June of 2015, is the land contract at issue. So that land contract, the June 2015 land contract, was attached as Exhibit 1 to the verified complaint. Yet in trying to avoid summary disposition, this plaintiff, 17-plus year real estate broker, submits an affidavit and says, it's the April 15. And therefore, only Cal was the one that signed. Therefore, it was reasonable for me to rely on some obscure email exchange that says nothing about extending the date for land contract payment, to prove that there's some agreement. This plaintiff knew full well, unlike many plaintiffs before this court.
Yes, counsel, I think we understand this point.
In that case, Your Honor, then I'll leave it to the context of the briefs and further support. And unless the court has any further questions, that's it.
I think it's clear from the brief. Thank you.
Yep, great. Thank you, counsel.
Thank you, Your Honor.
Okay. Anything, the opponents at all? Okay. That case will be submitted.
Thank you. Thank you.
Thank you. All right, so that concludes our 10 a.m. session. We will take a 5-minute recess.
All right. All right. The Honorable Court of Appeals of the State of Michigan is now in session. For case item number 22, the Honorable Ally Greenleaf Maldonado will be substituting for Judge Ackerman. Case number 22, item 22.
All right, thanks. Okay. Well, good morning. A little lonely up here, but not for long. Thank you, Judge Maldonado, for sitting in. As was just mentioned, this is the start of our 11 a.m. session today. We'll be starting with case number 22 with the panel of myself, Judge Maldonado, and Judge Kelly, who is participating remotely and unable to be here in person due to illness today, but she will be participating in the disposition of this case as well as the remaining ones today and is listening intently right now. So I will not repeat, all of the opening remarks from this morning, just a quick reminder that because these proceedings are being recorded and will be posted publicly online, for cases that involve children or other vulnerable or protected persons, please do not use their names, but instead refer to them by their initials or other identifiers that don't divulge any personally identifying information. So with that, let's get started with our 11 a.m. session. We'll call item number 22, case number 367-805. In re Higgins Lake. Mr. Ellison.
Yes, good morning. I think we're still good. Well, we're still good morning yet.
Yeah, still
Philip
good morning.
Ellison appearing on behalf of certain objectors who are joining me in the courtroom today, as well as on behalf of the Higgins Lake Property Owners Association.
Welcome.
Your Honors, the issue today that's before you is starts basically from the aspect that Roscommon and Crawford counties filed a petition asking the circuit court to allow them to create a special assessment district. But the request didn't have any project defined. It didn't have any cost estimated or even listed as a total amount. It had no allocation that each property owner who would be part of that special assessment district would be responsible for. And I think the most important part, did not establish the benefit that is constitutionally required for a type of special assessment. The circuit court, despite hearing all of these objections repeatedly, and I think one of the cute lines that Judge Bennett said in that hearing is the mood of the room is against what I'm doing here today. However, despite all those objections, he rejected every objection and granted the petition. But on the understanding, on the assumption that he likes to say, I'm not the tax man, I have nothing to do with the assessments. And we think that is a structural error of how this whole entire process is supposed to work. Our reading of Part 307 is there's two aspects to it. There is the establishing the lake level order, which is a case I've been before on the chill, we call it the chill case, the Citizens for Higgins Lake legal level. And this is the second part that does allow, and there's no dispute, it does allow for a special assessment district to be established. The problem is that the process that the counties have undertaken has said, we will establish the district and we'll let you know what amount, what your allocation is, and what we're going to do, anything later on. That bifurcated, or sometimes called multi-step approach, is inconsistent with what 307 actually provides. But even if 307 is if that is how the system is actually written by its plain language, it has to be unconstitutional because it doesn't allow for apportionment or allocation challenges.
So, yes, yeah, untangling the statutory scheme, I think, is part of the challenge here.
I agree.
So I see, MCL 324.30714. That talks about the making of a special assessment roll that describes the parcels of land to be assessed, the name of each owner of the parcel, and the dollar amount of the assessment against each parcel. Then there's the delegated authority shall set a time and place for a public hearing on project cost and the special assessment roll. At or after that hearing, the authority may approve or revise the cost in the roll. And then the special assessment roll with the assessments listed will be final and conclusive unless appealed in a court within 15 days after county board approval. So my understanding, and you can correct me if I'm wrong, is number one, none of that has happened yet. I take the court's ruling to say all of that is yet to be done. And when that's done, that's when you can go to court and bring these challenges to the roll and the cost that was approved by the county board and all that stuff. And what I'm doing here is just sort of the boundary setting. So that's, I guess, number one, that's my understanding of what the court did.
That is correct.
So then what is, and it sounds like a lot of the concerns that you and your clients are raising are ones that are encompassed by and contemplated by that statute. Is there anything? Yeah, I see costs, I see the assessment amounts, who's being assessed. So it sounds like you still have an opportunity procedurally to challenge all this at the county level and then at the judicial level. So what is, what's inadequate about that?
So the short of it is and again, I'm coming to you, I guess, kind of twofold. And I think you correctly identified is one, we need to untangle how do you read these? What's the procedure? What's the steps that this process provides? And it's our position to answer kind of your first part of your question to say is all this should be done before the court holds its, and I nicknamed it the fairness hearing, right? It's the review hearing in which the court reviews that whether the proposed special assessment district is in fact proper with the constitutional obligations of proportionment and proportionality and allocation that our takings and due process clause require for special assessment districts. The problem that I'm struggling to understand from this approach is how would a court know who would be in the special assessment district if you don't know what the project is and who's going to benefit from it? Because a allocation of or I should say the imposition of a special assessment district requires rough benefits to be received by the people who are actually paying that special assessment district.
Right, and it sounds like, that from my understanding, there's a methodology in terms of who has direct access or indirect access and sort of setting the boundaries in that respect. And then, I guess what I'm wondering is with the statutory procedure I just laid out in that one provision.
Correct.
I guess what prevents an individual at that time who says, hey, I really shouldn't be assessed anything meaningful with respect to this by virtue of my circumstances. My inclusion here is really tenuous at best. What prevents them from raising their hand at that point and saying, listen, once there is an assessment being put out, that listen, this shouldn't cover me. It shouldn't cover me the way you're saying it should. Why can't that happen?
Our position is that they should be able to raise that issue. And I'm going to come back to a point you just made for just a second. But to answer your question is it's our position, the way you read the statute is that gets to be brought up at the hearing scheduled at the circuit court in section 30707. Meaning this is the preliminary work that needs to be done. Because the one point you just made right now, and it's one example of many that, for example, pretend you're an offlotter or a backlotter saying, I shouldn't have to pay for whatever this project is. And again, there's kind of some built-in assumptions that are being baked into this, like this is going to be a project for X. We don't know what the project is. In fact, the project's never been defined as to what's actually being done for Higgins Lake. So maybe it's, pick a weird hypo. We're going to bring 10,000 trucks of water in to raise the level of Higgins Lake. A backlot owner could say, I shouldn't be involved with this at all because I'm not even on the lake. It doesn't benefit me. Contrast that with someone else's interest that says, I am a front lot owner, but I think it's being unfairly allocated because the south side of Higgins Lake has 100,000 people coming through the state park who are utilizing that property more. That allocation is unfair in this respect. None of that can be raised because none of this has been done now. And essentially the circuit court proceeding, if we adopt the county's position on that approach to say that you can do this bifurcated aspect, what was the purpose of holding a hearing in front of Judge Bennett? it would be a pointless exercise. It's our reading of the statute, which would be more consistent with the constitutional obligations to establish a proper allocation and proper proportionality, that the steps that should go forward is the county defines, we're doing this project, whether it's a new dam, whether it's bringing in 10,000 trucks, whether, you know, we're going to shoot rain clouds above, you know, rain seeds. I mean, you pick whatever your project is. Then you had defined the cost. And those costs then are, and because that's part of your preliminary study that's done under, that's provided for under the statute. And then those costs are proposed to be allocated in a particular fashion, whether it's everybody in the county, whether it's all the lakefront, whoever in this respect. And then anyone that wants to object can come to that hearing that is scheduled before the circuit court. And the circuit court then has a substantive obligation. Not, the joke almost is this, if we boil it to its core, and I don't mean to be disrespectful to a court in this, but in this respect, he's nothing more than someone serving coffee in a forum for people to come in and complain with no substantive responsibilities whatsoever. The point of that hearing is so that the judge gets to make sure that a proposed special assessment district actually complies with the constitutional and statutory obligations of proportionality, allotment, basic equitable fairness.
And
So
I guess my question is, I mean, so it seems like maybe there are a couple different ways you can do this, perhaps, maybe there is a, let's say the scenario is the county comes and says, yeah, we have a project about maintaining the lake level.
Right.
Okay. So that's our project. And we have a special assessment district that we want to approve, and it comes to the court to get that district approved. I guess what I'm wondering is, simply because here there wasn't as much substance as there could have been in this hearing, how does that prejudice your clients from being able to still be able to raise the concerns they have about whatever the project does end up being, when that project does in fact come to be?
So the answer, the short answer is I'm going to rephrase your question. I think respectfully is assuming we can do this, set the boundaries first without knowing the project and the cost and the allocation. We set who's going to pay the bill, and we'll let you know what the bill is later and what your portion of it is later. Is folks get due process on the first part. They don't get due process on the second part.
Why not? Why not?
There's no follow-up notice requirements. All the notice.
It's a public hearing, right?
It's a public hearing, but the notice for the hearing with the judge, it requires notice to be sent out by the government before to have that hearing. The second step process that's provided for does not have any notice requirement under the statute.
And I guess, but I suppose, in some ways, I understand what you're saying. There's no immediate prep to the extent there's no immediate notice of that public hearing. I mean, it's certainly, this first step does, if I'm a landowner and I've been designated for the special assessment district, that's some pretty advanced notice to be aware that this is something that could be coming down the pipe.
But in fairness, though, to the property owner, they get a notice that says you might become part of a special assessment district. They have no way to judge whether that special assessment district is fair, if it's been properly allocated. Is the people who are being designated to pay actually the true benefit? Because again, this constitutional standard for a special assessment district is that there has to be, and I'm going to use the phrase rough proportion. They've used different phrases throughout the last 100 years of the case law. But I use the phrase rough proportionality between the benefit received and the allocation of your cost to that aspect. There's no way a property owner could know that. So for example, and just as a weird example, I'm from Saginaw County. We live in a swamp. I mean, Saginaw County is a former swamp that got drained, 200 years ago. We have a special assessment for drains in that jurisdiction. The drain cost for me is about $8 a year. It doesn't cost me very much at all. I don't mind paying that contribution. But if the county's position on this bifurcated approach would be is that the drain commissioner would say, oh, we're going to put a new drain assessment on you. Okay, great. The most I've had before is $8. They establish my properties in the district, and then all of a sudden I get an $80,000 bill because they're going to build a giant aqueduct. I never had that opportunity to challenge that proportionality, which we think should occur at that circuit court hearing. And that may be our fundamental difference between our positions right there, is the when.
Right.
Okay. And I will say one of the things that's interesting about this statute is this statute's about 100 years old. This was here largely before a lot of our due process and special assessment case law came into, it got vacuumed into part three, the NAREPA, into part 324, or chapter 324. It's part 307 of that. I think this law has just never had any attention to it, and it's been utilized in large respect because it hasn't been very expensive. The project here, for example, I can pick, and I've given some kind of outlandish examples of, seeding the clouds and bringing in trucks. What if the county decided they wanted to repave I-75 during their portion of the property and say, because it benefits the Higgins Lake, and that's a cost that we're going to pass on to the lakefront property owner? That would be asinine, right? I think it would be unfair. When would they bring up that? Because
Why not when the special assessment roll is made and the project is saying, and they've gone forward, that the special assessment roll is determined, the assessment is listed. Why not at the public hearing then?
Because there is, I'll be clear, there's the judicial hearing and then there's the public hearing we're talking about. You get notice as a property owner of the judicial hearing. You don't get notice of the hearing for, you don't get the project itself.
But so that's I guess a little separate, I guess set the notice distinction aside. Let's say I'm at the hearing.
Right.
What stops me from raising all these arguments then?
You could raise, I think you could, in fairness, the short answer is I don't know, because there's been no case that's ever dealt with this before. We even talk about, you said there's the language in there about appealing that. Where do you appeal that to? Do you appeal that to the circuit court? Do you appeal that to the tax tribunal? Do you appeal, where do you go with this? It's my belief that the real reality is that how this process should work is before the local circuit court holds its hearing, and I know I'm somewhat repeating myself, but bear with me, is that all of this work is done so that when a property owner has full information in front of them to say, here's the proposed project, here's what it's going to cost us, here's what my allocation is, and here's why I am, and the amount that I'm paying I can see is going to benefit me X, in rough proportionality, it's constitutional. If I have information, for example, paving the I-75 example, and I get an $80,000 bill for repaving I-75, which is not connected to the Higgins Lake, I'm not getting the benefits from this. Other people are getting the benefit from it, and the allocation is unfair. It's our position that due process requires that be done with the circuit court process. Now, if this court concludes otherwise, we need to know that, and the real reality is let's just take, and I guess I would invite the court then, is if you're going to go the other way, which we would strongly advocate you don't, obviously, we would advocate our position is the correct one. But if you were to adopt the county's position, we need guidance on where do you go? Because there is no longer a hearing. There's no longer notice, and I say a hearing, a judicial hearing that's provided, and there's also no notice to us individually about to go out and to challenge these special assessments. What it is, it's no different than a public hearing that's held at among the many that the County Board of Commissioners hold on an ongoing basis. This process, and I come back to where I start from on this, is to say this is structurally in error. This whole process of this dividing aspect is structurally in error because it denies the cost and allegation information to be objected to on a proper basis. And what I would kind of parallel this to, I guess, is kind of my final thoughts. And of course, I'll answer any other questions the panel may have. But I'm from a little town up halfway between Saginaw and Midland, and my wife's on the school board. And they passed a millage to raise $40 million. And no joke, $40 million to basically rebuild the schools up in our area. It was a major political push. It was a major expense, a lot of money. Myself, I own a business that's there. I pay tax on. I have a house. You probably can guess how I voted because I live with my wife who's twisting my arm before we walk to the ballot box. But nonetheless, if the county's position is right, what the school could have done is say, we want to go to the voters and ask for a special assessment. We're not going to tell you what the improvements are. We're not going to tell you how much it's going to cost. We're not going to tell you what your cost is, the property. We want you to establish the boundary of the special assessment district, voters, and then we'll let you know later. And then my school district, in a fit of craziness, decides to open an auto repair shop on there and use the money from there for that. Now, that's an outlandish example, obviously, but it highlights.
We're mixing contexts.
But I understand. But it's the parallel. It's the parallel. In this instance, In this instance, the special assessment is allowed to be placed by the county petitioning a judge as opposed to going to the voters. And that's an issue for another day. But the issue here right now is when does that information have to be given to the individuals in order to comply with, I think, fundamental fairness? And fundamental fairness in our system is the label we put on that is due process. So what we're challenging here, to finish my thought here today, is we're challenging the structure and the process and the step 1, step 2, step 3 of how this statute should be read. And if it allows for that kind of process, that's why we have the constitutional challenge at the end of our brief to say, if this is how you agree that this multi-step process that puts the cost and the project definition and everything else to later without notice and opportunity to be heard, because again, it's notice and opportunity to be heard. It's not just post a public notice on a door that you could show up. If that's the case, then this statute, as it's been designed by the legislature, is unconstitutional, and we would ask the court to strike it. Unless the court, Judge Maldonado, you've been off in my peripheral view here with the cameras. I'm happy to answer any other questions that the panel may have today.
I don't have any questions.
All right, very good.
Not for me for now.
Thank you very
We have
much.
A few minutes for rebuttal.
Thank you.
I'm going to say good afternoon instead of good morning.
You got it.
Yeah.
Yep. Nailed it.
Stacy Hisson appearing on behalf of Roscommon County and Crawford County with regard to Higgins Lake. So where I think the confusion is for appellant's counsel is he's confusing the establishment of a special assessment district that stays in perpetuity with the levying and collection of special assessments that are for different projects during the life of a lake level. So what the process makes sense for a reason. And so you have the establishment of a lake level, and for this situation, this occurred over 100 years ago. Then
Last time was 2009, right?
the original establishment of the lake level was 100 years ago. So there was some revisions to the order under the court's continuing jurisdiction.
Right, but we had
in
a
2009.
reestablishment in 2009.
I wouldn't call it a reestablishment. I think there was some revisions to the court order. It was not necessarily a reestablishment.
What's
there-
the difference, I guess?
Well, if there's a change to the lake, in my opinion, there is no reestablishment. There's continuing jurisdiction to revise the court order, which may include the revision of the winter and summer level, a change to the boundaries, the time frame from which a winter to summer level changes, et cetera. And so there's the establishment of a lake level. The court has continuing jurisdiction to make changes during the life of that lake level. There's actually no statutory provision to dissolve a lake level once it's established. During that time frame in this situation, over 100 years, there's going to be changes that need to take place to that water control structure. Dams don't last over 100 years or shouldn't last. There's going to be, in due diligence of a county, things that happen over the centuries, perhaps, that require the upkeep, that mandate the upkeep of a water control structure.
How do you know what the right district is without knowing what you're going to do? I mean,
Okay,
there's some,
yeah.
there's some very
I'm getting to
fundamental
that.
intuitive appeal there, and there's also some statutory connection there where it talks about establishing the lake level and or like determining that and establishing the
district.
The district. So I mean.
Okay.
help me
So
understand.
yeah, I'm gonna get to that. So once you have a lake level, then the county has the responsibility to take care of that. And then the county also has some decision-making to do since 1969. Before 1969, it was county general funds exclusively that paid for that. But after the 1960 amendments, the county had the right to establish a special assessment district. You do that once. You don't do that every time you levy a special assessment for the multitude of projects that could take place over a period of years.
I mean, how do I know that from the statute?
Because
Because it seems like, it seems like you can determine a lake level, but presumably you can redetermine a lake level at times, right?
you can revise what the
So why
the
is
lake
this,
level
why is the
is.
special assessment district this one-off proposition?
So because you're established, because the court has taken jurisdiction over the lake level, and so the county decides, should there be a lake level and should we have a special assessment district? The circuit court decides what that lake level should be, whether there should be different levels. The circuit court makes that determination, and then the delegated authority takes the actions to operate, maintain, and improve those, and in some instances, construct the water control structure in the first place. So if this court was to read that every time there's a project, we have to go back to circuit court to have a new boundaries of a lake level established, I'll explain why that would be difficult at best and very, very costly to do each and every time. That doesn't make sense. So that how the court would decide who benefits from having a lake level itself. It's not really, and when you're establishing the special assessment district, it's not for one specific project. The levying of an assessment is for one specific project, and you do have the right to challenge that, as you noted, under section 324.30714, and that section specifically gives notice for that. But it's not a judicial determination of the methodology and a specific cost. It's who benefits from having, what properties benefit from having a lake level. In this situation, and in hundreds of situations throughout the state of Michigan, that is the circuit court's determination. I call it who's in and who's out. In this situation, as it is in many, it's those properties who are on the lake direct and then indirect access. They have some sort of private deeded access. That is not a like having coffee and decide anything. There's some people who come in and say, and certainly in this hearing, we think everybody in Roscommon County should be part of that. We think this is the best lake in the state of Michigan. We think you should be part of that. We think the entire state should be part of that. Everybody should be part of the special assessment district.
Why are you doing it now?
Why are we doing it now?
Why are you establishing a special assessment district now?
Because there is maintenance that needs to take place, not only on this lake and all three lakes in Roscommon County.
So why did that, I mean, if there's things in mind, if there's
Yeah.
projects in mind, why aren't they paired with the establishment of the special assessment district up front?
Because the special assessment district outlives any specific project.
That might be, but I mean, I guess we're establishing one at the outset, and maybe it's the case that establishment, can persist and make sense going forward for a lot of projects, but it seems like right now we're kind of just establishing one in the abstract.
Right, like they did in Ray Van Etten, because it can be a tool in the county's toolbox for the levying of a special assessment when it deems appropriate. Under Mr. Ellison's scenario, let's say I had a beaver dam that was built and it's blocking up the lake. And I had somebody go out and take that out, or I want to, and I'm going to spend $2,500. Under his scenario, I'm levying a special assessment. Do I need to go back to circuit court each and every time, notice 4,400 people, which will cost more than the taking out of the beaver dam, by the way, to have the circuit court, Judge Bennett, spend his time going over the methodology of how much each person should pay for the $2,500 to remove the beaver dam?
Well, there is a
That is
process
not-
for that though, right? I mean,
There's
you
a
have to-
process under Part 30714 that you first cited. That's the delegated authority that after this special assessment district is set by the court, confirmed by the court, then for this continuing operation and management, the specifics of a project takes place. And then you hold the hearing under 30714 where there is indeed notice and an opportunity to be heard to go over the specifics of that project cost, the computation of costs, the assessment methodology for that specific project, and then you levy the assessment.
So let me ask you this.
Yeah.
Are there any costs that can be put upon individuals that have been designated within the special assessment district? We have this district set now.
Yeah.
So can any costs be put upon them without them getting a further opportunity to contest their role in paying those costs? Or does everything, regardless of scale, have to go through that 30714 procedure?
So I'm going to say 307, you can't without going through the 30714 procedure, you can't levy any assessment without that happening. I'm going to give you, it depends though, because so in this situation where this district's been established, no assessments for Higgins Lake can take place without that 30714 hearing, 0. After that hearing happens, we go through the methodology. How much should the state park pay in relation to a backlot owner, in relation to a marina, et cetera? I'm not saying that, so that will decide there'll be a computation of costs, et cetera. In 2 years, if they spend $57 for a new board and there's a 25-cent assessment to everybody, I'm not saying that there's going to be a 30714 hearing in every situation.
Because that project has already had a hearing and the costs were different, or?
Because the apportionments have taken place for that. For sure, in this situation, you can't have any assessments until the 30714 hearing has happened because there hasn't been an allocation of the apportionments.
So
Just
the
like Mr. Ellison-
apportionments apply to, so the apportionments don't just apply to one specific project, they apply evenly to projects regardless of impact on the different parcels? Because I can see different projects having different impact.
Right. And so I've been asked this question by, I represent 60 different counties with regard to this, and I've been asked that question. The statute is, so for the specifics of this case, it's a slam dunk. You can't, because there's never been a 30714 hearing. When you're reading, when do I have to have a hearing? Do I have to have a hearing every year, even if I'm spending $25? I look to the section of 307 that says the levying and collection of special assessments should be analogous to the drain code. And so I look to the section, and again, it's unclear in the statute each and every time if you're spending a nominal amount of money, whether you need to do that or not, and if you don't change the apportionments between the property owners. And I realize I keep looking to a screen and that's not where the camera is, so I apologize to you. And so I analogize that to my clients as if you're spending less than $10,000, which is the nominal amount that a drain commissioner or a delegated authority can spend, and you use the same apportionments that you had in your last 30714 hearing, perhaps you don't have to have a hearing. That's very similar to Mr. Ellison. Every time he gets an $8 assessment from the Saginaw County Public Works Commissioner, there's not a separate hearing for that. It only when it meets a certain threshold.
30714 does seem to contemplate a project specific, project by project kind of thing. Now, I don't know what the scope of a given project could be. Maybe there's a project has, ongoing assessments, but it does seem to contemplate the delegated authority approving or revising, the cost of the project, or the special assessment role. So it does seem to inhere in that the idea of that we're kind of doing this on a project by project basis.
Correct. And that's why the circuit courts already don't really love having 3,000 people noticed and come in for the setting of the special assessment. They certainly don't want to have to do this each and every time there's a levying of a special assessment. And so I think that's where the confusion is. When you're looking at special assessment districts versus the levying and collection of assessments for ongoing infrastructure, there's not a redetermining of the district boundaries itself every time, whether that's the drain code, whether that's Part 307, whether that's an Act 188 district. It's the same district that gets established here by the circuit court that's utilized moving forward.
Now, if you're in the district, regardless of the kind of project, are you always going to have some measure of assessment, or can a given project, let's say there's a given project, I'm in the assessment district. Can my assessment ever be zero?
Absolutely. Absolutely. And that was discussed during the hearing. Yes.
That's based on the nature of the project. So
correct.
The fact that I'm in the special assessment district doesn't mean that for every project going forward, relevant to that district, that I will always have an assessment. It'll depend on the project.
Correct. And there may be situations where a portion of the district doesn't. So we have a lake that has a chain of lakes in Calhoun County. And so there's a couple of different water control structures. Some benefit parts of that chain of lakes that is all one lake for purposes Part 307 different. The methodology is going to be different. In the Heron Cove case that Judge Maldonado just heard earlier this year and decided on with regard to the Four Lakes project, there's two different special assessment rules with different methodologies for each of them. One for the big project for the Four Lakes situation, and one for operation and maintenance of the continuing operation of those structures. So there's going to be different situations, but it doesn't come back to the circuit court each and every time you have a project.
But it can. There's an appeal that you can take to a court.
Of your specific assessment, but not the confirmation of the district itself.
Right, correct. But if you, through that 30714 process, if you are, displeased by what your assessment is, what your role is in the given project, or even with the project itself, there's an appeal that you can take by statute.
Absolutely. And that's what the Heron Cove case was that was decided since the briefing took place in this case was an appeal of those very assessments under 30714.
I don't think I have any further questions. Judge Maldonado, anything further? Okay. Thank you, counsel.
Very briefly, I think again, we've been fighting about this for at length. Houghton Lake's coming up next on all these, but the problem is that there's a fundamental, I think, difference between what constitutes a project. And I thought I heard just now, and I agree with Sister Council that I draw parallels between this program and how the Drain Commission system works. I mean, and in fact, the statute even suggests to look to that for guidance for the courts on this. There are some assessments that I'm paying for in Saginaw County where they are building X, and I'm paying my proportional share of the building of that structure. So think about, in this context, would be the building of a new lake control or dam structure. There are other assessments like the Drain Commissioner one where they have come to me and said, we have a 20-year maintenance project where every year we have to do so much maintenance work and you are contributing X amount of dollars to that in a given year. Meaning, so the project doesn't have to be one build and done. It can be a maintenance style project that can go forward. And the problem that I'm hearing here from Sister Council is we can establish the district. We don't care who benefits. We don't care whether it's allocated fairly between themselves. It's just, we want this district and we will determine later how we're going to do that. And the problem is the constitutional standards that are applicable here say that it has to be fairly allocated across the entire district. Now, there can be some different classes and things, but I think you highlighted the very problem. You just asked the question, could my bill theoretically be zero? And if the answer is yes, that means it's not being allocated fairly across everyone in that specific defined district. Those are different districts now. That's the problem that exists. So as I see it, I guess to put it kind of at a 35,000-foot view would be is if Roscommon and Crawford counties wanted to money for building a new lake control structure and it costs $10 million, they're going to say this is the cost of it. This is how much. Here's the group of people that we are proposing would be responsible for paying for it. Here's the formula by which we're going to allocate. And then you have that hearing in front of the circuit court for the circuit court to do a substantive review on whether or not it meets the proportionality and apportionment standards that are required for special assessments. If the county wants to have a project that says we have a 20-year maintenance following that building of that is a separate project that exists. You define that district because as we just heard, and I actually agree with, different projects could have different beneficiaries and different costs to be allocated fairly across all those. So the reality here is the obligation to hold that hearing, the order of operations, maybe we should say, is that the 307-14 hearing should occur before the circuit court hearing on this, not after. Because if it is, all we're doing is the notice that they're proposing is it gets put in the newspaper. And next thing you know, my clients are paying for a pavement of I-75 that they didn't have any notice of. Decisions are made, and I have a 15-day window to appeal from that without having been given any notice as to what the decision on that aspect is. This statute has a structural error in its operation, and that's what I'm asking this court to correct. Absent correction by this court, I'd ask the court for very, very clear guidance on what we're supposed to do because we disagree with what Roscommon and Crawford counties are doing in the way they're creating these never-ending slush funds for the operations of these structures, maintenance and building of these things, that we really don't have a say as to what they are, even though we're the ones footed with the bill. And at the same time, we're also not given any notice as to what that actual cost and what our allocation is before it's kind of thrusted upon us and it's too late. So I'm asking that, so I guess in summary, unless the court has any other questions, is help us. Help us decide what 307 means because there are fundamental disagreements on how the order of operation should go and what the Constitution requires. And when I say common law too, common law and constitutional requirements when laid against 307. Thank you.
Thanks, counsel. Okay, that case will be submitted, and Judge Maldonado, thank you again. Right, I will take a short recess just to come back with another person.
Session, please be seated.
All right, we will now resume our 11 a.m. session with the panel of myself, Judge Ackerman, and Judge Kelly. And I think that leaves us at item number 20, case number 371-449, IMD, the Trinity Health, Michigan.
Good morning, Your Honor. Brennan Geese on behalf of plaintiffs appellants, Rebecca Arnold individually, and on behalf of next friend of mine, Doe. The plaintiffs appellants raised two primary issues in this appeal. The first is whether a mandatory reporter who fails to comply with the mandatory reporting requirements of the child protection law is afforded immunity under the act. And on this point, there is binding precedent, and that is the case of Levy v. Mills, 248 Mishap 244, in which this court found that even good faith reports are not afforded immunity when the reporter fails to comply with other provisions of the child protection law.
Levy involved the action at issue that was found to be outside the scope of immunity was something that the statute expressly prohibited, that it said you could not do.
Right, Your Honor.
That seems materially different to me from an activity like a reporting that the statute encourages and in fact requires. That's just not done in the time frame that it's supposed to happen.
Your Honor, the statute is clear that a mandatory reporter must make an immediate report. Now, good faith is presumed. However, the statute is clear that only acts done according to the act are afforded immunity. And so a mandatory reporter that fails to file an immediate report is not an act done according to child protection law. And that serves the interests of protecting children, making sure that.
Well, it seems like, doesn't it seem to disincentivize report? I mean, why are we only extending immunity to reports that are made within a certain time frame? I mean, it seems like our case law in general says some reporting is better than none. And there's obviously the prospect of significant liability that looms on the other side of not reporting.
And I could see that position, Your Honor, but here I think the facts are pertinent. 12 days passed between. There's nothing that changes between her concerns as noted in the documentary evidence, the medical reports, what is alleged in the complaint. Nothing changed between those 12 days. So if in the public interest to support the purpose of the act as stated, we shouldn't protect the reports that nothing changed. You should have reported it 12 days earlier or 9 days, or on that point, there's a question of fact as to when her suspicions actually arose, a point at which the trial court didn't actually address. They just summarily said she had reasonable cause clearly on that point. And this is the second issue we raise on appeal. The findings of fact regarding reasonable cause and good faith reporting were based upon what I could tell, nothing. I understand that good faith is presumed, but we presented evidence that her concerns as reported actually arose at least 9 days earlier, if not on the very first time that she met Doe, which is 12 days earlier. So
it sounds like there's no dispute that she had at the intake some concerns about her treatment regimen. But what prompted the reporting was, obviously the treatment regimen was relevant to that, but it was the degree of mother's involvement and whether that involvement rose to the level of, in the reporter's mind, abuse. And it seems like there is a material factual distinction between having some general concerns about what's happening, with this individual, and then having that develop into a reasonable suspicion that this individual is actually being subjected to potential abuse.
Right. But the case law is also clear on that point that mandatory reporters are left with almost no discretion on this point. If you suspect that
Well,
And-
not to investigate, once you have the suspicion, but then but there's a point where you have to get to having the suspicion of abuse. What you aren't supposed to do is then take a lot of time to investigate the abuse. You're supposed to report. But you have to get to the point of having a suspicion of not just maybe something's wrong, but a suspicion of abuse.
Correct, Your Honor. And the documentary evidence presented in the trial court was clear that the records say, I have concerns about mother's involvement here. All of the medical records were presented to the defendant doctor. If she reviewed them, should have known that the medicine actually was helping Doe. It was necessary. She had finally come out of what was a 5-year span of hallucinations, of psychosis, and all other sorts of ailments. And had she looked, she would have known not to be concerned about this, not to report. And I think what's most telling is there's nothing in the record on the day that she made the report to show what suddenly happened that elevated her concern to reasonable cause to suspect child abuse. There's nothing in the record that, other than the fact that she was going.
Confrontational argument about the care, right? That was pleaded.
That was days prior. Yes.
You're right. Then that was, where there was, say a very, I guess confrontational conversation about whether this course of care would be changed. And obviously there was significant disagreement there.
And I would like to point out that the mother actually, for lack of a better term, gave in to the doctor's demands and agreed to adjust one of the medications.
I believe the complaint, I think, pleaded a potential adjustment to one of the medications.
Correct. And but on the day that the reporter, the doctor, defendant here, did make the report, the only thing in the record is that mom told a coworker of the doctor defendant, I'm going to report her to a supervisor. And I think on that point, the trial court also erred in finding that a retaliatory report is not in bad faith. I struggle to find a few other reasons that a report could be in bad faith, and retaliatory reports is one of them. Falsely reporting is also another one.
But I think my understanding of the case law is that, there just needs to be a reasonable suspicion. Maybe the fact that something may also have, some personal animus involved or something like that doesn't defeat the notion that there may be reasonable suspicion that informs it as well. And you kind of just have to focus on that piece.
I agree. There does need to be a reasonable suspicion, Your Honor. And as we pointed out in the brief, that suspicion arose more than a week before she actually made the report, which is in direct violation of the statute. But that's not an immediate report. That's what that boils down to.
I have no further questions.
Thank you, counsel.
No worries.
Good afternoon, panel. Erica Yost on behalf of Trinity Health and Dr. Ryan. The panel made some good points that were also in my argument during appellant's discussion, but I'll just go through this briefly. Dr. Ryan is a mandatory reporter. She's required by statute to report when she has a reasonable suspicion or a reasonable cause to suspect child abuse. That's what she did here.
I guess what to the point of not reporting sooner?
To the point of this isn't a case where a child came in with a black eye or a broken arm and had, obviously something happened. Dr. Ryan's a psychiatrist. This patient had, as is detailed in the complaint, this patient had a significant psychiatric history. She started treating with her on May 3rd, and their physician-patient relationship, I think, concluded May 12th. And during that time, brother counsel mentioned that nothing changed. I mean, the doctor was seeing the patient every day. She was interacting with the patient and her mother. She was gaining more information about the patient's medical picture. So the thing that changed was her knowledge. And as the pleadings and as the briefs point out, yes, she did have this extensive history that Dr. Ryan could see to begin with. So understandably, just because she has may have a disagreement with a patient's course of treatment doesn't necessitate a CPS report. But these other things that happened during the course of her treatment with the patient are what created in her mind the reasonable cause to suspect child abuse that she reported. The immunity through law is, as was mentioned, good faith is presumed. There is still no evidence of there's no evidence, there's no claim of bad faith here. The delay alone, there's no support for
Well, they plead retaliatory motive. And they
but
plead
they're
bad
not
faith.
saying that there's no claim that her reasonable cause to suspect child abuse was false. She didn't make a false report, is what I'm saying. And I don't think there's any support for the position that a delay arises to the level of an alleged delay arises to the level of bad faith. And I think the fact that this is that Dr. Ryan was exercising some clinical judgment. This is not this is a reasonable cause to suspect child abuse that would be obvious to anybody. She gained it through her involvement in treatment of the patient and her mother. Appellant's position that this should have immediately been reported on the first day of treatment, I think that requirement would create a chilling effect on mandatory reporters. If they, like, oh, I should have had this thought, a week ago, I better not report.
But wouldn't they also be subject then to the flip side of the criminal and civil liability that would come from not reporting if some harm results? It seems like if the way it works is that if you don't, if you don't report immediately, you lose immunity, then you have the choice of either going ahead and reporting and being potentially exposed to a lawsuit of this sort, or you have the decision of not reporting. And then if something bad happens, you're subject under the statute to potentially criminal liability for not reporting.
That's correct. But I think the way the statute is drafted is to encourage reporting,
right,
and to protect our mandatory reporters, because it's, to protect children's safety. And I think that's the way it should be interpreted here. There are some evidentiary issues with the report. The May 12th date, which is the date that appellant is saying that the call was made, is not pled in the complaint, nor do we have the CPS report saying when that was actually happened. So we don't actually have evidence that that call was made on the 12th. There's just some uncertainty around that time frame. There's also nothing in the complaint saying that Dr. Ryan knew about, she obviously knew about the interaction with the mother. She had the interaction with the mother. Whether she knew about the complaint that the mother may have made to another of the coworkers, which I don't know if you even went further than that, there's no claim that she knew about that. So again, these are not
beyond just the allegation that it was retaliatory because of that, right? I understand what you're saying. There's no factual pleading about how she may have come to that knowledge.
Right.
I understand.
Right. And I also want to point out that immediate is not defined in the statute and means different things in different circumstances. For instance, when you have something happen right in front of you versus when you have a long relationship with a patient and you come to a conclusion based on your impression after over a long period of time, which is what happened here. And I think there's nothing else for me unless the panel has any other further questions.
No question. No further questions for me. All right.
Thank you.
Thanks, counsel.
Thank you.
Sure. Yep. You got a few minutes.
On the facts of this case, it's improper to grant C7, C8 when so many clear factual issues remain, as sister counsel, pointed out, that we're not even sure when the phone call was made. We're not sure, the trial court didn't find when the reasonable cause to suspect child abuse or neglect arose. On the facts of this case, I think it was improper to grant C7 and C8, Your Honor. That's all.
Understood.
Thank you.
Thank you, counsel. Okay, that case will be submitted. Okay, moving on to item number 21. This is case number 372-256. Aceves v. Wester's Family Vineyard and Winery.
Good afternoon, Your Honors. Marco Lewis appearing on behalf of plaintiff appellants. I just want to go over a couple of the issues raised in our brief. The first one being the issue of the genuine issue of fact regarding the act of the fall. Police argue that Mrs. Aceves did not know how she fell, whereas as she testified in her deposition, she was asked, and I can quote from her deposition directly, the question was, and you didn't actually see your heel stick in the slats on the stairs. True. And she answered, true, but I felt it. And that's on page, I believe it was 72 of her deposition. That fact, coupled with the, as we had talked about in our brief, the soles of her shoes ripping off, those two facts combined are enough to create a genuine issue of fact.
As to the causation.
As to, yes, as the causation. The defense or the appellees in their brief analogized this case to was just cited in their brief as Lowry. And I believe the full citation was Lowry v. LMPS and LMPJ 500-1. That is a different set of facts in this case. In that case, the plaintiff had just testified that, and it was quoted, a person can't just slip on nothing. In this case, Mrs. Aceves did not just testify, well, I was walking on the stairs and I fell, ergo it was the stairs. She specifically testified that she felt her heels get stuck in the stair boards. That is different, that is stronger testimony than what was seen in Lowry. And again, coupled with the shoes being torn off, the soles of the shoes being torn off, those combined create a genuine issue of fact. As to the duty issue, the appellee cited it was Bertrand v. Allen Ford, that steps do not pose an unreasonably dangerous condition. And we agree with that. But the court in that same case also said that they may pose an unreasonable risk of harm due to their character. And that character, in this case, is what is at issue, and that is that gap between the stair boards. Our argument is that this kind of venue that hosts weddings and formal events, they're inviting people in who are going to be dressed in attire like myself and brother counsel are wearing, and wearing heels. There should not be any kind of gap in stair boards.
Yeah, where's the record support for that proposition? I mean, do you have anybody, I guess, tell me sort of what in the record is supporting that notion.
Sure, we think this is just a common sense argument of when you are inviting people in, they say they host about 50 weddings a year. When you're having 50 wedding parties a year at your establishment, you are inviting people who are wearing high heels to your establishment to walk up these stairs. There should not be any gap that any high heel should be caught in. And we don't have an expert to testify. There's no, code regulations on gaps of stairs that we could find. We think this is just a common sense argument of when you're inviting these people in who are going to be dressed wearing high heels, there should not be any gap that these heels can get caught in.
Any high heel conceivably, or any shoe, or I guess, yeah, what's the standard of care here?
We think it should be that if you're at a venue holding yourself out to invite formal events, weddings, where people are going to be wearing, attire such as heels, there should not be any gap within any stair boards or any boards where those heels can get caught. And if that just requires using one solid board, that's fine. If that means having the boards completely flush, that's fine too, but there should not be any gap in those boards. And I guess along the same lines, the argument that the appellees did not know that this was an unreasonably dangerous condition based on no one ever having fallen on the stairs in the past, it essentially gives defendants everywhere a free pass for the first time someone is injured on their property if no one else if no one else had been injured before.
What about the idea that this was something, I mean, we're in a post Kendall saved world. So, open and obvious is not gone. It's just not duty, right? And it's mixed in with the breach, notions of comparative negligence and all that stuff. But there's still, I think, there's still extant in the law, the idea that there's, an ordinary person would discover this on casual inspection, whether that's an expectation. It seems perhaps that inheres in those latter elements. But talk to me about that. I mean, we have these stairs. I understand your position that I guess it's one of defective design. But why are these a dangerous condition, where there's a genuine issue of material fact that these are the sort of dangerous condition that would constitute a breach of the standard of care? It's something that somebody wouldn't just, notice and say, hey, I look at these stairs, I see this little gap, I need to step carefully.
I think the argument would be that, excuse me, the argument would be that Mrs. Severs does not know, the width of her heel versus the width of the stair board. How is she to know that that gap in the boards is wide enough to accommodate her heel? And I believe she had testified, and I don't know exactly where in her deposition it was, that she had been watching where she was going. If she was watching where she was going and she didn't appreciate the danger of it, I think it was just because she didn't know that her heel would be able to fit in that kind of gap.
Got it. So there's no argument here that, the gap, was obscured, or, sometimes we get cases where like, oh, we can't really see what the problem here is. This is a visible thing. It's just from your perspective, it's just, this is designed effectively, and there's not any way anybody, an invitee would reasonably be able to appreciate that design defect until it's too late. Is that?
Yeah, that is fair, Your Honor. And
okay,
unless there are any other questions, I think that basically about sums up my argument.
Okay. Thank you, counsel.
Thank you.
Good afternoon. May it please the court, David Nelson, appearing on behalf of the appellee. I guess I just want to point out a few things, and then I will predominantly rely on my briefs in this matter. But I think the first thing I'd like to point out is that the standard announced by appellant's counsel is essentially one that would hold a business owner to be an insurer of anyone who is on their property, which the court has held that that's not the standard here. I think the main points that are crucial in this case are that there is no evidence that the defendant, the appellee, had any reasonable notice that, first of all, there was a dangerous condition on land, or that the condition, if you want to call it that, the steps, constituted an unreasonable risk of harm. And there's several factors that go into that. The first being that they have hosted numerous weddings at this location without any incident. They'd never been put on notice that there was any problem with the steps.
Well, I mean, just to back up, they know how the steps were built, right? So they're aware what the steps are, but this just hasn't happened before, is what they're saying. Like this problem hasn't arisen with the design of the steps.
And there also is no reason to believe that they could appreciate that these steps themselves would create an unreasonable risk of harm. And the reason for that is that
I think a lot of those points go to, weight and or for the jury, so like, was it an unreasonable risk of harm here may depend on in front of the jury that you'll make the argument that there've been so many weddings and it, you could see it and things like that. But at this stage, I feel like there is like a, dispute as to that. And that's not something we can make as a matter of law necessarily.
I respectfully disagree with that, Your Honor, because under Lowry, which I apologize, I realize the site was not included in my brief for whatever reason. But
We
in
see Lowry a lot. We're
Yeah.
familiar.
Right. So in Lowry, the court held that it is the plaintiff that has the duty to,
or the obligation to show that the defendant had notice, and not that, it's not the defendant's burden or obligation to show they didn't have notice. And I think in this case, the plaintiff has not shown that the defendant had notice of the condition at issue here, or that the condition posed an unreasonable risk of harm.
So, but short of somebody falling, how would you have more notice? So tell me what you contemplate would be adequate for notice. Because like I said, we know there's no dispute, you know what your stairs are. That's what makes it a little weird, right? We're not talking about like, oh, there's a wet spot that nobody knew about. Like, these are just how the stairs are built. So we know about that. And we know that, you know, the record doesn't appear to contain evidence that anybody previously had fallen, right? So, but short of somebody injuring themselves, you know, what would it provide? Like, what sort of notice do you feel like your client needed to make them, you know, liable for these steps?
Well, respectfully, Your Honor, there was nothing visibly wrong with the stairs. I mean,
Not in disrepair. I think the theory is design defect.
Correct.
It's just like we just built these in a way that doesn't make sense for this venue. But I think that's the theory. But I guess, so where is the notice of, I guess, what further notice could your client have had, short of somebody hurting themselves, that these stairs were defective such that the switch would flip from not liable to liable?
If someone reported that they saw an abnormally sized gap in the stairs and they're like, hey, you should get that fixed.
I mean, they already know about the gap.
Well, they don't know that it's and poses an unreasonable risk of harm if there is a gap. I mean, the pictures don't even identify a significant gap in those stairs because they're taken from a front on angle. So there's nothing in the record that actually shows that there is a gap in those stairs. Secondly, there's nothing in the record that establishes that if there is a gap, it violated the standard of care in any way. There's no testimony from any expert. There's no affidavit from any expert establishing that that this gap, however big it would be something outside the range of what is normally accepted when somebody constructs stairs. So I think there's proof lacking there that this is even a standard of care issue. I think the standard that they have espoused here, which has no support in the record from any expert or anything, is that no steps should never have any gap in them whatsoever if you're at a venue where there's weddings, which I think is not, first of all, is not supported in the record, and secondly, it makes them insurers of essentially anyone who is on their property to attend an event. So I think with respect to if you go back to the reasonable notice issue, I think the fact that there was no evidence of any type of problem with the stairs, there's no evidence that they constructed them improperly. So there's no evidence that the defendant had notice of any design defect, because, you know, there's arguably, if they want to say, well, there's notice because they constructed the stairs, that's not applicable here. Because simply constructing the stairs, there's no testimony that the defendant constructed them improperly from anybody. And you have to have that testimony in order to prove a design defect case.
I think their theory, right, is that the steps were built in this certain way and everybody, you knew how they were built. And then, you know, high heels are what they are. And the wedding venue, you know, is what it is. And you're on actual or constructed notice that folks are wearing that kind of shoes. So you combine those things and that creates this, at least fact question about a breach of the standard of care. And so where's in your view, what more is needed for there to be? I take it from your perspective, that's not enough as a matter of law. It's just not enough to create a fact question as a breach.
But correct.
So what more? Tell me what more would get them there. What should they have done here?
In order to create a fact question?
Yeah, you know, what would create a fact question here? Expert testimony?
I think what would create a fact question is some evidence that the stairs were actually defective. Some concrete evidence showing that there's a defect in the stairs that violates some applicable standard of care, other than simply there shouldn't be a gap. Because if that's the case, then this is not really a negligence theory. It's a res ipsa theory that these are these stairs and they're automatically a problem, so therefore you're negligent. They haven't proven what standard of care exists or how the standard of care was violated. And under Bertrand, ordinary stairs in and of themselves are not an unreasonably, they don't pose an unreasonable risk of harm, and they're not a dangerous condition, essentially. Under the Bertrand case, this case falls squarely within Bertrand because there's no evidence that these stairs were anything out of ordinary stairs. There's no evidence that stairs can't have a gap in the boards at all. There's been no testimony or evidence to that effect. So absent any such testimony or evidence, these are simply stairs that exist. The plaintiff fell on them at a wedding. There's no issue of fact in that circumstance because as a matter of law, Bertrand holds that those are ordinary stairs and they're not unreasonably dangerous. So I think that's where their problem is here, Your Honor. And I think with regard to the other arguments that they raised at the beginning, I rest on my brief in that regard.
Further? Okay, thank you, counsel.
Thank you.
Thank you.
Any rebuttal?
Your Honors, any rebuttal I have would likely just be a repetition of what I had said before, so I'm just going to rest on that and what is included in our brief just to respect the court's time. Thank you.
Thank you, counsel. All right, that case will be submitted. All right, so we already did item 22, so we're going to item 23, case number 374043, Cardiff v. Goss.
Good afternoon, Your Honors. Kevin Gentry on behalf of the appellant mother. It's late in the afternoon. I'm not going to keep Your Honors here much longer. Basically speaking, this is a case where the parties don't get along well enough to do joint legal custody. They can't communicate. In fact, the appellee cannot communicate with my client without using swear words or descriptions of anatomy. It's not good. They have no ability to be joint legal guardians. There should have been a sole legal custody determination here under Daly, Boyceville, Wright, Cardiff. This court has repeatedly held that when two parties are at loggerheads and cannot communicate effectively for the children, that's not going to work for joint legal custody. And that is true in this case. It's not that they don't like each other. Of course they don't like each other. They're divorcing. They're on the other sides of family law litigation. It's that they can't communicate without Benz. I mean, even in app close, he's using language that is, well, I can't say it on YouTube, quite bad. And that's a real problem. And that's where the trial court made a mistake here. And there was definitely
considered that, right, and reached a conclusion. And, you know, it's not that the court didn't consider that, it just did. And you disagree with that conclusion. But obviously, you know, in these matters, you know, our review is rather deferential.
There is significant deference, Your Honor. But I think on these facts and these exhibits and this communication, this falls squarely in the Daly Boyceville category. The other issue which I wanted to bring up is the parenting time issue. And that's concerning because we didn't know it was a concern. The referees.
It was an issue. I mean,
it was an issue before the referee.
Right,
it was not an issue in the objections. The objections only brought before the trial court the issue of joint legal custody versus sole.
But I mean, the trial court is, I mean, this started with the trial court. The trial court referred it to the referee, and the referee is there to make recommendations. That's very clear. Like the referee's just making recommendations. And then you can object to some of those recommendations. But I guess what I'm not seeing is, you know, anything that says, well, you know, what the trial court can do with respect to sort of the original dispute that was brought before it is narrowed by the time it comes back to the court, just based on what people object to or not. I mean, if a referee makes a recommendation and for whatever reason it doesn't get objected to, I mean, what binds the trial court to that recommendation if the court looks at it and says, this does not seem right?
The trial court under Harvey certainly can do that. However, it has to give notice and opportunity under 3.215 to say that there is the opportunity for new evidence on this issue. Had we known parenting time was an issue, my client wouldn't have said, there's no new evidence on joint legal custody. We've turned in all of our exhibits. She would have said, let's talk about parenting time. Put me on the stand and I'll talk about that. I have new evidence. I can talk about how these children have been interacting, or how this child has been interacting with their father, how much difficulty there is, those sorts of things.
It's just not seeing what actually ever, ever foreclosed that. I understand you're saying that you wanted the court to, be more affirmative, but it seems like, obvious parenting time could have been objected to, number one, if she didn't get her complete relief. And then even going forward, it seems like there wasn't, obviously you have the objections here and it's gonna, your full conversation will focus on the objections, but there wasn't ever a, any sort of statement by the court that I'm not hearing anything more about parenting time or anything like that. It just.
Remember, the parenting time award was in her favor. It was not that she could have objected, it was the other side could have objected.
Well,
but they
didn't
didn't.
she originally request full suspension?
She did.
Right, so that
But
was.
she was satisfied with what the referee gave her.
Well, that may be, but it was partial relief from what she requested.
She had no idea that the trial court was going to reconsider parenting time, and therefore, when she waived her right to present new evidence, she thought she was waiving it on joint legal versus sole legal custody. She didn't know she was waiving it on parenting time because she didn't know that was still up there, because nobody had objected to bring that before the referee or before the judge. If the judge had said, well, I'm going to reconsider parenting time because I think this is askew, then certainly she would have presented evidence without that notice.
I think that's kind of where it doesn't seem like it's it seems like the court has before it parenting time and it's gone to the referee for help in sorting that out. But it's not, I feel like this may be sort of misconstruing the role of the referee in this process.
3.215, or I'm sorry, 3.215 F2. To the extent allowed by law, the court may conduct a judicial hearing review of the referee, but the court must allow parties to present live evidence in a judicial hearing. The court may, in its discretion, prohibit a party from doing evidence and calling new witnesses unless there's an adequate showing that the evidence was not available before the referee. I think that's really what we're.
I'm seeing in that rule, it may prohibit a party from presenting evidence on findings of fact to which no objection was filed.
Yes.
So there's no, that seems to create, so no objection was filed to this. So the court, under the court rule, had no obligation affirmatively to take new evidence. I understand you're saying that you wish it had been discussed more, but I guess what I'm having trouble finding is, I understand how you wish it had been done differently, but I'm having trouble finding is that reversible error.
I'm having trouble thinking as the attorney for my client, if I read 2A, which Judge Ackerman just did, the court may prohibit a party from presenting evidence on which no objection was filed. I'm not sure I even can present that evidence. I mean, it says may, so the court could allow it, but at the same time, it's saying don't bother the circuit court with evidence on issues that aren't before it. And that's what I think my predecessor counsel read it as. And that's why my client didn't present any evidence on parenting time. And that's why we'd like to be heard on parenting time on remand, because there's some stuff that's gone on. Thank you, Your Honors.
Thank you, counsel. I don't think opposing counsel is endorsed, so I think
She did not file a brief, Your Honor.
correct. So the matter will be submitted. Thank you, counsel. Okay, and that brings us to item 24, case number 372298, In Carpenter Minors. Neither side is endorsed for argument, so that matter will be submitted on the briefs. And with item 25, 373113, In Wing Minor, the same holds true. Neither side is endorsed, so that matter will be submitted on the briefs as well. And that concludes today's case call.